Okay, now.
We're going to get started. Would you like to stand up?
We have feedback. Oh, when you hang it.
Oh. I shouldn't have banged it 3 times. Sorry. So we have a little change in the order of things today. We're going to do Representative Bunker's bill first. And Senator Rachel Talbot Ross is over an hour away. And she wants to present her bill here first before she presents it in judiciary. So we thought we would have the presentation next, and I don't know how long that will take, but maybe an hour. Oh, okay. So
Be as brief as the other two.
okay. So to begin the meeting, I'm Senator Penny Beebe Center, and I'll be presiding over this public hearing today at the Joint Committee of Criminal Justice and Public Safety. The purpose of the hearing is to invite testimony from members of the public regarding proposed legislation that's pending before this committee. The committee will hear testimony from persons present who wish to speak for, against, and neither for nor against the bills to be heard today. With leave of the chair, committee members may ask questions of any person testifying today. Other questions are not permitted. Whether or not you testify, you may submit written testimony to the committee. Please be mindful that testimony is public. It is available to all once it is presented. Persons testifying at the public hearing today are advised that the hearing is live streamed and may be seen and heard by persons watching online, and that a recording of the meeting will be archived. Those who are joining us through Zoom, if the name you used to sign into Zoom is not the same name you used on the legislature's website to register to testify, it may be difficult for us to identify you when it is your turn. We won't close the hearing until we've given everyone on Zoom an opportunity to testify. And if you're having any technical difficulties, please call our committee clerk at 287-1122. And if you're in the room and have prepared testimony, please provide 20 copies to our clerk. And it's important that you sign in when you deliver your testimony. And please turn all electronic items down. Silence them. Thank you. So the first bill we're going to do is Representative Bunker. An act to establish a 1-year probationary period for public safety dispatchers. Beg your pardon? Introductions. Could we each introduce ourselves, and could we start with Representative McIntyre?
Good morning, Madam Chair. Good morning, colleagues. Matthew McIntyre, representative for House District 18, 16 towns across portions of Penobscot, Hancock, Washington County. And I'd like to say the town of Great Pond, looking forward to hanging out with you Saturday for the fishing derby.
Good morning. I'm Representative Chad Perkins. I represent District 31, which is 7 towns in southeast Piscataquis County.
Good morning, everybody. My name is Mana, and I represent District 95, which is part of Lewiston.
Good morning. I'm Representative Bob Nutting. I'm pleased to represent the snow-covered people of District 66 in the beautiful Belgrade Lakes region.
Representative Tavis Rock Hassenfuss, House District 57, with the beautiful Lake of Maranica covering both Reedfield and Winthrop. And unfortunately, I report that I will not be attending the fishing derby because I will be at a hockey tournament.
Representative Ardell?
Yes.
Good morning. My name is Donnie Ardell. I represent House District 6, a series of towns in central and southern Aroostook County.
Morning, I'm Representative Steve Bunker from District 75, which is Farmington and Chesterville, and I'll see you all at the Wilson Lake Ice Fishing Derby this Saturday.
Good morning, everyone. I'm Representative Michael Joy. I represent District 96, which is part of Lewiston.
Thank you very much. Representative Bunker?
It must be free fishing weekend this weekend.
Yes, for children.
Yeah.
That's why we choose,
Well,
that's why we choose it.
Fishing about everybody is so. My kids.
Good morning to the audit chairs and my fellow colleagues on criminal justice and public safety. I'm Steve Bunker from District 75. I'm pleased to present LD 2090, which is an act to establish a one-year probationary period for public safety dispatchers. And I'm prepared also to offer a friendly amendment once we get to that point from my original document itself. Currently stated by state statute, the probationary period for public dispatchers is 6 months. And I was called upon by interested parties to recognize how this profession has expanded over time and its level of training and the complexity and the role it plays in emergency calls, that there may well be a need for communication center managers to have a longer period of time to evaluate the knowledge, skills, and aptitudes necessary to bring somebody from probation over to full-time dispatchers themselves. I'll have to say, from my background and experiences in 911 that go back many years, I've seen this profession expand tremendously with the amount of advanced training and certification and state licensure that they have, and the amount of aptitude and skills, not only to learn the computers, the software, the protocols themselves, but also to be able to have that skills, to be able to know how to manage callers and be able to properly deal with managing the callers, and in many stressful situations where 911 is the caller's not their best day, and being able to function under those stressful conditions. And because of that, I was approached and asked if that probationary period should go from 6 months to 12 months. Following that, I've had some additional discussion with interested parties asking that if I would consider a intermediary measure, and my amendment for you does just that. That would ask that the probationary period be no less than 6 months, which it currently is now, or more than 12 months. That would give the opportunity for the employers at their choice to stay with the current 6 months, or if they choose that they need additional time to properly evaluate the performance skills of a dispatcher, to extend it out to as much as 12 months. And because that would place various options from one center to another, I add in an additional paragraph A, that an employer must adopt a written policy regarding the length of that probationary period for public safety dispatchers, so that they could disclose that to the dispatcher at the time of hire, so that it's not changed for the employee after hire itself. And I'm hoping that that meets a good balance between the interested parties there, and recognizes the skill set that dispatchers need to be able to perform during probation. I would be pleased to offer questions, and I do have parties in the audience that have working experience in this area that I'm sure could add to my testimony.
Are there any questions for Representative Bunker? Do we have anybody online?
No.
For this bill?
Oh, wait a second. We do, I'm sorry, yes. But don't we have to go through all this? Anybody?
Right. Representative Perkins, Please.
So I was just looking at Title 26. There is no 600 seats now. So currently there is in statute no minimum, in my understanding. correct?
No, the current one is 6 months. It's in a different title.
It's in a different, okay,
It's over in Title 30.
okay, that's what I was, so the
Yep.
current probationary
Yep.
period is 6 months.
Title 30 has a lot of employment guidelines generally for public employees. The Title 26 that I refer to is more specific.
Okay. All right, that's,
Yes.
Thank you, Madam
Representative
Chair.
Nutting.
So this bill doesn't appear to change wherever it is in the statute currently.
Correct?
Failing to do that, wouldn't you have two different laws for the same thing?
It would focus it directly on this Title 26, Section 600. It would be only there.
Okay.
Representative Ardell.
Thank you, Madam Chair. So how much formal training does a brand new entry dispatcher get? And is it on-site or is it off-site?
It is a combination. The bureau that provides for certification of dispatchers, which is under the 911 authority, has a basic week of training itself, both an introduction to the general practice of public safety dispatchers, plus additional training in the actual operation of their call answering technology. Then added to that, there's additional days spent in training them specifically to emergency medical dispatch, then additional time to emergency fire dispatch, plus additional time on the Metro and NCIC systems themselves. And then beyond that, there's very extensive in-house training at the centers themselves. So it can extend over a period of many months.
Does the training time, is that included in the initial probationary period?
Yes.
Okay, thank you.
Are there other questions for Representative Bunker? Seeing none, thank you very much. Is there anyone that would like to speak in favor of this bill? You have these people, they, signed up. No. They're not online. No. Oh,
It's just these people.
oh. Welcome. Would you introduce yourself?
I wasn't sure I had to wait for her to finish, so.
Okay.
Yes, Senator BB Center, Representative Hassenfuss, distinguished members of the Committee on Criminal Justice, Public Safety. My name is Michael Labby. I am the Director of Emergency Communications Bureau at the Department of Public Safety for the state of Maine. And I have appeared for you today on support of LD 2090 and its act to establish a one-year probationary period for public safety dispatchers. The required training varies for a public safety dispatcher or an emergency communications specialist, as we refer to them, if they work at a PSAP or a non-PSAP. PSAPs are required to attend, I have a lot of acronyms here, but ETC, EMD, EFD, Pro QA, NG911, and TOC training totaling 18 days of training outside of the center, while a non-PSAP will attend only ETC and TOC totaling 10 days of training outside the center. Each communication center varies based on geographic coverage, number of agencies they perform dispatching services for, or type of responders, such as if law enforcement, fire, rescue, et cetera. I'm the director of the 3 PSAPs that operate by the state of Maine. Each of the 3 centers have different duties and responsibilities, and we currently have a 6-month probation period. With the required 8 days of training outside of the center, and you add to the regular days off, it takes almost a month of training time away from that 6-month period, leaving us only 5 months in that probationary period. Emergency communications is a high stress and demanding profession. There's a lot of information that needs to be learned by new team members in a short amount of time. A 12-month probation period gives all centers, regardless of size, geographic coverage, or number of agencies they serve, adequate time to assess team members and help them pass the training program and successfully complete probation. I'm open to any questions if anyone has any.
Are there any questions? Representative Ardell?
Thank you, Madam Chair. And thank you, Mr. Labby. The how long does it typically take for a new hire dispatcher to get up to speed to be considered, like a fully operational?
So that really does vary from center to center. Like we have, like I said, we have 3 centers that we cover. I'm the director for the state of Maine. Our Augusta Center covers all state agencies for 11 counties. Plus, we dispatch for Kennebec County Sheriff's Office currently, Gardner Police. We have multiple fire and rescues in Kennebec County. We have multiple fire and rescues in Oxford and York County that we dispatch for. So that's a giant geographic coverage area. We have 2 CAD systems we're using currently. So the amount of information they have to take in is not just simply answering the call, inputting the call, dispatching the call. That in itself is quite lengthy. A lot of times, 6 months, we're barely making it because we don't know, which is not enough time. Whereas like our Bangor Center, they have 4 counties of state agencies only, and they don't dispatch for any other outside agency. So a 6-month period for them is a good window. They still have that same out of the office training, but where they only have 4 geographic coverage of counties plus just state agencies, it's a little bit easier. They can get that 6 months without pretty much an issue. Our Holton Center is similar to us. They have just the 1 county, but it's Aroostook County, which is quite large. They dispatch for 2 local police agencies, and they have local fire and rescue. So again, it's 6 months is okay, but if we had more than 6 months, it'd be better. The reality is to really do this job and feel comfortable, like you've mastered it, it's 2 or 3 years. So a 6 months window is really tight. A year would be a better window to help us make sure everyone succeeds. The hiring process is lengthy from when you post it to when you hire someone and get them in the seat could be almost 2 months in itself. And then you're going through that training period. So like, I personally want to see everyone succeed, and you've invested a lot of time and money and effort to get them there, and to have to cut short because that training window is so short is kind of regrettable.
No, I understand. I guess the follow-up question is has there been, in recent history, new hire dispatchers who, have exceeded that 6-month probationary period and for some reason haven't been able to make it? I mean, has there been evidence that the additional 6 months would have made a breakover for employees that it ordinarily wouldn't have had?
I can't give you figures, I guess. Like I can't pull numbers and go, yeah, I hired 27 people in the last 3 years and 26 washed out. But if I would have had more time, they would have made it, because I don't know. We're not allowed to extend probation.
How about this for the work session?
Yeah.
That'd be a good thing.
Okay.
See how many people that between 6 and 12 maybe washed out. Thank you.
Representative Perkins.
Thank you, Madam Chair. So in the past, historically, you got some municipal fire departments. You look at Milo or you look at Lincoln, where they would have one employee that would sit at the firehouse and he would dispatch and coordinate the apparatus that were responding to a fire scene. And that was their local dispatcher specifically for fire protection. Are they covered under this? I mean,
So
because I'm looking at paragraph C here, it says someone answering, directing, or dispatching the response of emergency services for municipal fire protection pursuant to, I mean, first of all, does that still exist in the public safety world, in the fire world? And if so, are those people covered by this?
So my interpretation by the definition when I read the additional LD was, because that was the question I had for Representative Bunker, was, is we referring to just PSAPs or non-PSAPs? So for clarity, a PSAP is a public safety answering point. If you dial 911, your call goes to a PSAP. We have 48 dispatch centers in Maine. We have 25 PSAPs. So there's 23 other dispatch centers that are non-PSAPs. So that's why there's different levels of training. By that definition, that was put down there for what a public safety dispatcher is. To me, that includes everybody, PSAPs, non-PSAPs, and includes like, say, Fort Kent PD, who has one person that sits in there, and they also do hunting and fishing license and sell bread and et cetera, et cetera. So if you're dispatching a responder of some kind, you are a public safety dispatcher.
Yes, Representative LaJoy.
Thank you, Madam Chair. Looking at the amendment presented, would that satisfy you in regards to the ability to have only a 6-month probationary period if another dispatcher came from another 911 center? And so, I mean, if he's gone through, or she has gone through all the training and so on, and I would say has been at that center for a period of time.
Mhm.
I think they probably wouldn't need that 1-year probation.
And I'm not going to disagree with you on that, sir. We have hired team members that have experience elsewhere. Maybe they dispatched Oxford County. So when they come aboard with us, we still have on the state level, we have our minimum training blocks that we have. Our training program has 6 blocks. Each block has minimum amount of time and maximum amount of time. And that's how we go through the training process. And you have to achieve 4 consecutive days or 3 or higher in the SEGs to advance. And even for someone that's experienced, when they come on board with us, they still have to go through that 6-block training program. It just won't take them as long. And once they've successfully passed our training program, then they would be released on their own. It won't take them 6 months. For us, the probationary period doesn't affect rate of pay. It doesn't affect anything of that nature. So it's not like you pass probation, then you go to another pay level or et cetera. I know some agencies are affected by that. Like you start at a certain pay, once you reach probation, you get a bump. So that would affect them. It doesn't affect us in that rate. But if we hire someone with experience, yes, they're going to get cleared quicker once they get through the minimum amount of training blocks.
Okay, thank you.
Yeah, welcome.
Representative Perkins.
Thank you, Madam Chair. So just to follow up on my previous question. So historically, from my very limited experience from what I've seen, a lot of times in these, and then I'll use, for example, Milo Fire again. A lot of these local municipal fire departments, they have their own frequency. They're not taking calls from the public. Again, they're only dispatching their own people, their own equipment. The person who's sticking on that radio is maybe someone that's been in that fire department for years, but has gotten to an age or condition where they're no longer responding to the fire, but gives a good job for them. Does that person have to go through the dispatcher training down at the Criminal Justice Academy, or historically, do they do that?
So in that instance that you're giving there, they would not attend the ETC or the TOC training, because the terminal operator certification, which is through Metro NCIC, that's CJIS security, and they would not have access to that in their role. So they would not do that, and they would not need to go through the ETC as well, because they're not taking direct calls from the public.
But that you then looking at this paragraph C, answering, directing, or dispatching the response of emergency services, that they fit that definition, and would they fall under that is my question. Because they're directing fire response. I just don't want to.
No, I get what you're saying.
I get what hindering somebody.
I get what you're saying on that. Can you verbatim again for me, please?
So it says paragraph C, answering, directing, or dispatching the response of emergency services for municipal fire protection.
Yeah, I mean, if they're dispatching their fire units and they're the ones responsible for monitoring, maintaining them, and assigning them to CAD, that sounds to me, based on that definition, that's what it would be. I don't know how many of them there are that still do that, but
I can tell you there's probably more than a few, especially in our more rural areas.
I'm not sure. I know I can't think of any off the top
Maybe
of my
Representative
head.
Bunker can shed some light on that for me at some point, but and again, my limited experience in fire service as a volunteer, working with other departments and what I've seen. I just say, I don't want to create a loophole is what I'm saying. I'm not saying I'm against this. I'm just want to make sure we got all our bases covered. So
I understand.
Are there other questions? Yes, Representative Nutting.
Thank you, Madam Chair. My experience with employees in a probationary period comes from the retail setting. So when I hire a professional with a license, like a pharmacist, for instance. They come in, they are what they are. If I hire a cash register clerk, there's no professional title. So there are two types of hires.
Mhm.
The probationary period, whatever it is, at the end of the probationary period, those, particularly in state government, what happens to the benefit of the employee when the probation period is over? Are they then not able to be fired without cause?
Essentially, yes. So we have that window where if it's not working out, we can show just cause through documentation why it's not working out. By that 6 months at this point, because that's what we have right now, we can serve them their 3-day notice. They're allowed to have a union rep come, even if they're not part of the union, and meet with the director and plead their case as to why they should or shouldn't be held on to service.
So that from the day they're hired until the probationary period is over, whatever it is,
Yeah.
are they being trained? Do they gain some certification of training or?
So there's no, so like when they go to the ETC and EMD and EFD at the state, which is 45 Commerce Drive, same building I'm in, through ESCB. Yes, they get certifications there that they'll maintain if they pass those classes that are good for 2 years. When they go to TOC through Metro NCI school, they get a certification that if they pass, that's good for 2 years type of thing. So that if they go somewhere else, they already have those certifications. If they pass our training program, there's no certification. It's just you passed our training program. Here's our documentation showing you passed our training program. With the 6-month window we have now, sometimes you get down to the end and we're not allowed to extend probations for us. So with 6 months is a hard stop. At 6 months, we would now, I don't want to say it becomes harder to release someone, but that's ultimately what it is. If I'm not allowed to extend a probation past 6 months, if I don't know if they're going to work out or not, if I'm not sure, then we kind of cut ties, which is a shame because we've already invested so much time and energy to try to get them to where to succeed. And if we hold on to them and it's still not going to work out, well, now it's detrimental to the team because the amount of effort, paperwork, et cetera, to go through the process to release someone at that point is hard.
Retail is simpler. Thank you.
You're welcome.
Are there any other questions? Yes, Representative McIntyre.
Just thank you for being here
No
today.
problem. Thank you.
Does your team have anything that resembles what's known as a PIP, Performance Improvement Program, where say somebody's beyond their probationary period and they slip and you decide maybe there's something there, maybe there's not?
Yes.
Okay.
Yes, we do have those. We do have PIPs. If something happens after someone's been with us for some time, they make a mistake or whatever happens, or we see the numerous mistakes being repeated.
Mhm.
You know, mistakes are allowed to happen as long as we learn from our mistakes, don't repeat them. But if we're repeating our mistakes numerous times, we can create a performance improvement plan and go through that process. Yes.
Thank you.
Yes, Representative LaJoy.
Thank you, Madam Chair. I was on the board of directors for the Lewis and Auburn 911 for a number of years. And of course, it's unionized. When you mentioned that in your situation, you cannot move it beyond 6 months, would this bill help out in the negotiation process? It would have to be agreed to by the union and by management, of course, that you could extend it to 12 months.
So currently, there's nothing in our union contract that limits the probation period. It states once you pass probation, you are allowed to become a member of the union.
Okay.
It doesn't have a finite time frame. The 6-month time frame is established by, I don't know if it's Title 30 that Mr. Bunker talked about earlier, but it's the directive from our HR that it's 6 months. The only time we've ever been allowed to extend it past the 6 months is if that team member went on a leave, like say they had a baby, so they were out for an extended leave while they're in that probationary period. So we have to make up that time they were out. We're allowed to extend it that way because it's a detriment to them. They missed all that training time, so obviously not going to pass training. But that's the only time we've been allowed to extend it past the 6 months.
Are there any other questions? Representative Hassenfuss?
Thing is, so what I hear you saying essentially is that because it's at a 6-month period, you err on the side of caution. And when there's somebody who is borderline and you really need more time to determine whether they're going to be a successful employee or not, you release that individual because you don't want to take the risk that if you go past that 6 months and they don't improve, even though you anticipate they may, then you can't release that individual. So is that essentially, what you're saying is that?
Yes. Yeah.
And yeah, and then just going along with Representative Ardell, it'd be interesting to see how many individuals have been released at that 6-month period because of the uncertainty as to the longevity of that employee. Yeah.
I can try to put those
Yeah.
numbers together.
For the work session. That would be good. Are there any other questions? Seeing none, thank you very much.
Thank you.
Is there anyone else that would like to speak in favor of this legislation? Is Tanya Emery online?
Is she has to, she's.
Okay. Miss Emery,
Yes,
ready? Okay, thank you.
I am. Thank you so much. Senator Bibi Center, Representative Hassenfuss, and distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Tanya Emery, and I am here to deliver testimony virtually in support of LD 2090 on behalf of the Maine Municipal Association's 70-member Legislative Policy Committee. Municipal officials support and recognize the need to align the probationary period of dispatchers with other law enforcement officers. And in light of the amendment offered by Representative Bunker, the sponsor, I think it actually strengthens our support as there is the ability to customize at the level of the employer based on what works, that no less than 6 months, but no more than 12 months. I think that's a great addition, and the written policy necessary certainly is a best practice. Extended supervised experience for personnel dealing with potential life and death situations makes sense, not only for dispatchers, but for the public that they serve. The Legislative Policy Committee did have some questions that the committee may wish to consider, and I think you're already diving into some of those matters. When does that probationary period begin? In some other statutes references, it is clear that it is upon hire or upon certification. That might be something that would be clarified through this process. And also, will provisions be made for dispatchers that are already working under an existing contract or collective bargaining agreement? Thank you for the opportunity to present testimony today and to share the municipal perspective. And I'm happy to try to answer any questions that you may have.
Miss Emery, have you submitted your testimony? Do we have copies? We have it. Oh,
It was
okay.
submitted online.
Okay, thank you very much. Are there any questions for Miss Emery? Seeing none, thank you very much. I hope you'll come to the work session.
I will be there, and I apologize for not being with you in person today, but you'll see me again soon. Thank you.
Okay, thank you. Is there anyone else that would like to speak in favor of this legislation? Is there anyone that would like to speak against this legislation? Mr. Doyle?
First off, I do this so many times, I don't unmute, so I hope I'm unmuted and everyone can hear me.
You're unmuted.
Thank you. Senator Bibi Center, Representative Hassenfuss, and distinguished legislative members of the Criminal Justice Public Safety Committee. My name is William Doyle, currently I serve in the role of Executive Director for the National Correctional Employees Union, or NCEU. The NCEU represents 9 county correctional units, including dispatchers in the state of Maine, comprising of approximately 500 members from York to Aroostook County. We've been advocating for correctional communication and law enforcement salaries and benefits since 2010 in the state of Maine alone. The NCU would like to thank sponsor Representative Bunker for your efforts in support of the law enforcement community in this bill as well as others. However, the NCU rises in opposition to this proposed bill requiring a 1-year probation period. Under the current state statute, 30 MRSA 2701, employee probationary periods for public employees are set at 6 months, except as specifically provided otherwise by charter or ordinance. This proposed law would extend the current probation period to 1 year, not to mention undermine collective bargaining. Probation periods outside of the law are mandatory subjects of bargaining. Many collective bargaining agreements allow for increased probation periods and mutually agreed upon extensions. The proposed change is another example of attempting to fix a problem that does not exist. If changed, the employer would be able to dismiss, suspend, or discipline employees for up to 12 months without just cause or cause at all. The imposed discipline or dismissal would be outside the collective bargaining agreement and not subject to the grievance and arbitration provision of the contract as it stands today with the 6 months. Management currently has 6 months to decide whether an employee is a good fit or not up to the essential functions of the job. Essential functions is the key point in that. There was a lot of discussion today about folks that take on PSAPs and non-PSAPs and, you know, the varying nature of communities that the agency is dispatching for. But it's the essential functions that you have to look at, whether an employee can do the essential functions of the job. That's what a fitness for duty evaluation would be. There's no good reason to extend the probation period for the hardworking men and women who answer the call and are subjected to forced trauma when the phone rings. Let us not forget communication officers were added to the rebuttable presumption disability legislation regarding PTSD due to their work. And, you know, before I close, I just want to point out that management always has the right to negotiate probation periods above the 6 months, you know, in negotiations, and again, offer something to those employees if they want those employees to live by this at-will status for their probation period. In closing, the NC would like to reiterate our opposition for LD 2090, urge the committee to vote ought not to pass. Thank you for your time. Happy to answer any questions.
Are there any questions? Yes, Representative Ardell.
Thank you, Madam Chair. Thank you, Mr. Doyle. I'll ask the question I asked before. Have there been historical issues with work performance that have sort of reared their ugly head, you know, between 6 and 12 months? So, I mean, I suppose the question is there empirical, historical evidence that this bill is necessary, in your opinion?
No, the bill is not necessary, and I'll explain why, because the answer to your question is yes. Have people made mistakes or gotten into issues during their probationary period? Yes. And what has happened in some cases, management has decided to retain that employee and work on that employee, and eventually that employee you know, does great things in their career. But moreover, also, employers have come to work with the union and say, hey, can we extend probation? And those extensions have happened by mutual agreement. So in this case, this is an example of attempting to fix a problem that doesn't exist, because the employer and the union have the right to work on this and deal with this if issues arise. You know, one of the things that we've encountered as an organization is management fails to do their 3-month review, their 6-month review, and then wants to come for a extension with no bona fide issue during that 6-month time frame. And again, 6 months is a long time to assess whether somebody can do the essential functions of the job.
Follow-up question?
No? Thank you, sir.
Are there any other questions for Mr. Doyle? Representative Hassenfuss?
Thank you, Mr. Doyle. How would you respond to, you know, my previous question that given the 6-month cutoff, that some employers may err on the side of caution and release an individual where, if the probationary period were extended, they may be more willing to work with that individual, extend that so that they can get to the necessary essential functions of the job. I just worry that having that hard 6 months cutoff may in fact lead to more firings than necessary.
So Representative Hassenfuss, that's a great question, but again, public safety dispatchers, there's an extreme shortage of dispatchers out there, and so more often than not, employers are keeping folks on and working with them long term. Now, there are some that they feel don't meet those essential functions, and they do release those within the 6-month window. But in the NCU's experience, more often than not, if somebody is working towards progress, the employer keeps them. And again, this is a situation where collective bargaining and this mandatory subject of bargaining of probation periods, the employer can negotiate that into contracts or go to a union and say, hey, this employee needs a little bit more time. These are the reasons why. Would you agree to a mutual extension of 3 months or 6 months? And that has happened. And so again, this bill would undermine collective bargaining and the ability for the employer, the union, and the employee to work together to find a reasonable resolution that fits everybody. Again, if you pass this, public safety dispatchers will have no recourse. They will be at-will employees for 12 months. That's a long time for somebody to be able to just come to you and say, yeah, we no longer need your services. Here you go.
A follow-up question, Representative Hassenfuss?
At what point do they start paying union dues?
Thanks to the legislature's foresight in one of the previous sessions, they can, I believe they can start being a unionized or they can start belonging to the local union or their chapter. I believe it's within 30 days of starting. But again, they don't get the just cause protections of the grievance and arbitration procedure, even as it stands today for that 6-month period in accordance with 30 MRSA 2701. For 6 months, they can be released at any time for any reason.
Yeah, but when do they actually start having withdrawals from their paycheck to go to union?
Whenever they sign up for it. Remember.
And they can do that within 30 days?
I believe they can do that within 30 days because of the previous legislative decision.
Okay, but they have to at 6 months?
No, remember, Janus versus AFSCME, the Supreme Court decision that came out in 2018 outlawed the mandated dues. So dues are just, if somebody wants to join the union and start paying dues, it's at their discretion, not the unions. There's no more closed shops per se. So they're not forced to join the union, but they still get that protection under the law of collective bargaining. They get that protection after their probation period, not before.
Representative Lookner, would you introduce yourself also?
Well, thank you, Madam Chair. I'm Grayson Lookner, representing House District 113, which is part of Portland. And thanks, Mr. Doyle, for being here. I'm just kind of wondering about the broader landscape of collective bargaining for public safety dispatchers. Is the NCEU the only union that represents public safety dispatchers in the state, or are there other unions / non-unionized public safety dispatchers? And if you know percentages or rough ballpark figures about those numbers.
I don't know the percentages, but I can tell you the NCU is not the only union that represents dispatchers in the state of Maine. There's a couple of different agencies that represent dispatchers in different facilities. And then there's a couple of dispatch units, I believe, that are unrepresented. So I couldn't tell you the percentages, but I know there are other unions that represent other communications officers in the state of Maine.
Thanks for that answer. And do you know, have they taken a stand on this bill? Or are they aware of what's going on here with this legislation?
As the executive director of the NCU, I can't speak intelligently on the inner workings of the other unions, or I don't see anybody here, so I imagine they're not here. But again, the NCU is here fighting for our members and even our non-members, because this is an important issue. This happened, if you remember, this happened in 2008 with corrections officers before the NCU was in the state of Maine. Corrections officers had a 6-month probationary period, and the legislature changed that at the suggestion of a county out of southern Maine that decided to bring forth a bill, and a legislator was willing to support that. And unfortunately, today corrections officers have a 1 year probation period outside of collective bargaining. And that's what this bill would do here today, is set up that same sort of scenario.
Are there any other questions for Mr. Yes, Representative Bunker.
Morning, Mr. Doyle. Thank you for having us here. You made the reference a couple of times about essential functions of the job. How do you identify that for the group that we're talking about?
Thank you for that question. Obviously, each individual department has a job description, and that's the job, right? Those are the essential functions of the job. It usually says so on the job description. What are the essential functions? And so employers, again, if they're doing their 3-month review and right before their 6-month review, if they're doing their reviews and actually training employees the right way with field training officers and so forth, 6 months is a large enough window to say, okay, this person is up for the task, or this person needs more training, or this person is not going to get it. But again, I don't want to discount the fact that it's collective bargaining, and at any point, the management code can go to the employer, or excuse me, the union, and say, hey, we have concerns. These are the concerns. Can we extend the probation? And the NCU, I know, and I'm sure other unions have as well, we've done that. Again, because we want to work together with employers to resolve issues rather than deal with the legislature and have them step on collective bargaining rights.
Is there any other questions for Mr. Doyle?
Yes.
Please.
Thank you.
Follow-up question?
Follow-up question. I'm confused by your concern about the 6-month probationary period, when in my proposed language that allows it for 6 months up to 12. Why does that not allow the latitude you're suggesting for collective bargaining units in the employer to make said agreement to extend it if need be? What is your objection to that?
So thank you. Unfortunately, I only saw the amendment this morning. I didn't see that before when I wrote the testimony. The amendment on its face probably is okay. The fact of the matter is, though, until collective bargaining units come forth at negotiations at their specific times, the employer can make the move to, just put in a policy that puts them out a year. And so, again, without collective bargaining, these employees could see their probationary period just jump. Again, because collective bargain, I mean, I guess you could do there could be an impasse, or excuse me, impact negotiation based on a law change. But again, employers could implement faster than the unions could negotiate. Because again, negotiations come up at certain intervals unless both parties are mutually agreed to open up a contract mid-contract. So again, I don't know that I have to look at the amendment a little more based on the way you presented it. It might work, but again, it's going to have an immediate impact versus collective bargaining, which would take time to implement in negotiations.
I would end by saying I took you at a disadvantage because you've not seen my my amendment that I offered this morning, but I was sensitive to that issue, and to respond to your question, I made sure that there was a section in there that required the employer to identify at the time of hire what that probationary period would be. So it's clear to all parties. And I wanted to be sure that that did not interfere with any collective bargaining issues. If employee, employer, and the union came to some degree of agreement as to what those months would be, I see nothing in my proposed amendment that would prohibit that agreement to happen. But I will leave it to you to let you look at my language, and at work session, I'm happy to listen further.
May I respond?
Please.
The only thing I would say is again, I think if I understand you correctly, and if I understand what you're looking for in the amendment, the parties, the employer and the union, already have the right to bargain probation periods beyond the law. So again, why is this bill needed? Why isn't it? Why wouldn't we just allow employers, if they want to have a higher degree of probation for each individual place, as Director Labby pointed out in his testimony with regarding PSAPs and non-PSAPs. Why doesn't each individual place negotiate with that union for certain probation periods related to their needs? This would be a blanket that, again, it can already happen if the employers negotiate. So I don't know that this is a fix that is necessary.
Are there any other questions for Mr. Doyle? Seeing none, I hope you'll be at the work session.
I do plan on being at the work session, and I apologize due to the storm and some other factors. In a meeting I have to be at. I couldn't make it up there today.
Okay, thank you.
Thank you all.
Is there anybody else that would like to speak against this proposal? Is Paul Gaspar on? Is there anybody that would like to speak neither for nor against?
Yes.
Yes, okay.
It just has to turn on this camera.
Okay. Hi,
Good morning. Good morning.
good morning.
I apologize for not being in person. I've been beset with labor issues for a better part of the morning, irregardless of snow removal. So thank you for the opportunity to join by Zoom. My name is Paul Gaspar. I'm from South Portland. Good morning, Senator Beebe Center, Representative Hassenfuss, members of the committee. I have submitted testimony online, but I don't want to waste too much of your time. So I'll allow you to read that. We're neither for nor against, only because I knew there was an amendment pending. However, I have not seen it yet. So based upon that, I would rather be in the neither for nor against, because if we're able to come to an accord, we would otherwise support the bill. And I'd like to thank Representative Bunker for taking the time to talk with me on the phone and discuss some of our concerns. I'm here on behalf of Maine Association of Police as their executive director. We represent about 850 municipal and county law enforcement officers and public safety dispatchers. So we're coming because we were approached by our own members who are dispatchers with some concerns about the bill as it's originally written. And from the law enforcement side, we come at it from a different perspective, only because not only is a newly hired law enforcement officer under the 6-month probationary period under Title 30A as a municipal employee or a county employee, they may be at the police department 6 months before they even go to the academy. And then under Title 25 and Title 30, after graduation from the academy, they have a full 1-year probationary period. So I don't view it as unplowed ground. And I can't speak for the correction side, but if I had to make an assumption, it would be because they are also certified by the academy. That may be the nexus of why they chose to impose a 1-year probationary period as well. I can't say that for sure. It just seems to track. As originally written, we had concerns, much as have been expressed before, mostly because we felt that the language was duplicative, where we already had language under Title 30A, which garners both municipal and county. In talking with Representative Bunker and saying, is there any way we can find an accommodation in the existing statutes rather than to create a whole new one? And he was very good and sought that out. And it eventually became, at least to my understanding, and Representative Bunker may have some further information, is that what we didn't take into account for was an entirely other additional statute that covers only state employees, because we don't represent state police dispatchers. So it really presented a conundrum to try to change all three of these statutes. And in my conversation with Representative Bunker, it seemed the best route to stay with the bill as far as putting it into Title 26, however, giving the leeway of not less than 6 months, not more than a year. And because dispatchers are not certified by the Academy, there's no provenance or history there to point either way. I think we share the concerns, as Mr. Doyle did, about the effect on collective bargaining agreements. However, knowing that there's already an existing 6-month period, most of those things are covered in collective bargaining agreements anyway. And I would assume that in the event of a municipality wishing to change from 6 months to 8 months under this proposed bill, that because it's already ensconced in the collective bargaining agreement, that they would have to submit an intent to bargain, a 10-day notice, of which the union does not, it's not mandatory. You can request it, but both parties have to agree to come to the table to negotiate it. And if the union was not comfortable negotiating that at the time, if they were in a current contract, they could certainly deny the request to bargain. So we think that, maybe there should be some language that points to, unless pursuant to a current collective bargaining agreement, but I think that's really language stuff. The other thing is that many of our municipalities who abide by Title 30A, some are 6 months. I look at the city of Portland in the police department, they have a 2-year probationary period. And the current language in Title 38 allows for that. It's a little wonky language. It refers back to prior probationary periods or prior to 1984. But in general, what we see is anywhere from 6 months to a year anyway. So where we view this, and in talking with our dispatchers, they know that there's a considerable amount of training that somebody has to go through alone, let alone how they respond to the rigors of this job as a dispatcher. And I can tell you, MAP has fought for 15 years to change the thinking that not only are dispatchers fellow first responders, but they can fall prey to the same things that a law enforcement officer on the street contend with, as far as PTSD, traumatic events, and in some cases, their experience with trauma is amplified by the fact that, one, there's really nothing they can do. They have to sit there on an open line and listen to it unfold. And two, they never really get a resolution to it. They never find out what happens. So they carry that situation with them. So in Representative Bunker's attempt to, one, define a public safety dispatcher and then assign a probationary period, I think on its face seems reasonable given what we have already. But again, we want to be able to retain as much of the local control and the ability to bargain those things as possible. And I think I'm happy to do session. And if the amendment can achieve that, and again, I apologize, I haven't seen the amendment, that we would support that. So, but as written now, we would rather be neither for nor against than just straight out opposed. So I'm happy to answer any questions the group may have, and I really appreciate your time and ability to join by Zoom.
Are there any questions for Mr. Gaspar? Seeing none, I hope you'll come to the work session.
I absolutely will.
Okay,
Did I not do it right? I didn't get any questions.
thank you very much.
All right. Have a great day, people.
You too. Is there anyone else?
No. No, there's,
Okay, so we will close this public hearing. We, again, if we could have the presentation, the next bill, the person for the next bill hasn't arrived yet. Would that be okay to have you present? Not you. Oh,
Josh, so it's Lauren Stewart, Director of
oh,
Highway Safety, and then
I'm
Josh,
sorry.
you're on
I'm
the same page.
sorry.
Yep.
Okay.
okay,
Please.
Good morning,
Good morning.
Senator Senator.
Do we want?
I can stand.
Okay, yeah.
She your left, and your left.
Yes, I did it. Okay.
Thank you.
Good morning, Senator Beebe Center, Representative Hassenfuss, members of the Criminal Justice Committee. My name is Lauren Stewart. I am the Highway Safety Director for the Bureau of Highway Safety located in the Department of Public Safety. Very pleased to be here this morning to share our report with you. I think you'll remember that this resolve originated from a bill from last session, LD 1135, which was discussing uses and of oral fluid testing in the state. And we felt at the time that there was a lot of unanswered questions, and we felt that bringing together a group of experts to talk through all the issues regarding oral fluid might benefit us all in the end. So if it's your pleasure, I would like to invite Traffic Safety Resource Prosecutor Joshua Saucier to give you the report out, because he was the primary author of the report. And he is online and prepared to do so.
Thank you very much.
You're welcome.
Thank you, Lauren. Good morning, Senator Beebe Center, Representative Hassenfuss, and all the members of the Joint Standing Committee on Criminal Justice and Public Safety. Apologize for not being there with you in person. I have a rather thoroughly broken ankle and get to be housebound. As you probably know by now, I am Joshua Saucier. I'm one of two Traffic Safety Resource Prosecutors for the state of Maine. We are contractors for the Bureau of Highway Safety, working with a small company called Dirigo Safety, LLC. To start, I guess I will start with just some background on oral fluid testing so we're all on the same page in what we're about to talk about. There are generally two types of oral fluid testing, okay? The first type is what we call roadside oral fluid testing. These are essentially screening devices that occur with an officer at the roadside. They are sort of handheld instruments. A tube of sorts goes in a suspect's mouth. They force saliva into it. The instrument reads that sample, that tube, and prints out what is suspected to be in the person's system. It is those roadside devices are only sort of screening devices. They are, they're not really intended for court use. Although I will tell you, Tennessee has put in statute an attempt to make them available for court use. The other type is commonly referred to as either confirmatory or evidential oral fluid testing. This is a type that essentially a sample would be collected post-arrest. So at the time that essentially a blood test or urine test or a breath test is collected, this sample would go to a lab. And at the lab, it would go through at least two different sets of testing. It would go through a screening test. that generally says, hey, here's the drugs that might be in the sample. And then it goes through confirmation testing using chromatographs and spectrometers to say, here is what is in the sample. And that in Maine is typically in Maine, at least our blood testing, urine testing, and who oversees our breath testing is the Health and Environmental Laboratory, which is part DHHS, which is part of the CDC. That's the background. I can pause here to see if there's any questions on the background. If not, I'll go right into the report.
Are there any questions? Yes, Representative Ardell.
Thank you, Madam Chair. Two brief ones. So the roadside, presumably a roadside positive could be utilized to develop probable cause for arrest.
It's a great question. Here's the situation in Maine. I look at roadside very similar to how I look at PBTs. Okay, they serve the same purpose. PBTs, portable breath tests, alcohol tests, essentially at the roadside. In the state of Maine, PBTs are not generally admissible in court, which means when it comes to court, if there's a suppression hearing, we don't get to use it as evidence of probable cause. It can certainly influence an officer's decision, but when it comes to proving it probable cause, it's difficult to get to use them in court because you have to prove the reliability, which means they really need to be overseen by the chemistry, by HEDL, and they aren't, because that would take a lot of people. Does that answer the question?
Well, kind of, but it opens up another question. If you have a roadside test that is not accepted, an acceptable element of probable cause or isn't considered one, why even have one?
I can tell you the working group was not in favor of roadside oral fluid testing for that reason.
Okay, thank you.
Well,
Are there other questions? Seeing none, please continue.
Thank you, Senator. So, as to the report, first, the members of the working group, sorry if I make that mistake again, were extensive. It was the Bureau of Highway Safety, it was the TSRPs, it was the Secretary of State's office, it's Maine Criminal Justice Academy, it's the Maine Chief of Police Association, it was the Maine Sheriffs, it was HEDL with DHHS and the CDC, it's the Maine Prosecutors Association, and it was the Maine Association of Criminal Defense Lawyers. Those were the organizations enumerated. Each one of them appointed an individual, and all of those individuals participated fully in the meeting. And all of them, by the way, really truly were experts in this field. Additionally, the Maine Warden Service was invited and had an individual who's also a drug recognition expert join us. Maine State Police joined us, and eventually, actually, we got an assist from the Maine State Police Chief Pilot, because as you remember, there's a little bit in here about airplanes. So first, thanks to all of them, and thank you to both the individuals and the organizations. It was actually quite a great experience to work with all of them. We met around 8 times. Our goals essentially in meeting were to address the questions posed to us by this committee. Those questions were the state's need for and intended use for oral fluid testing, including to Representative Ardell's, I think I got that right, question in whether it should be used to establish probable cause or for evidentiary purposes. 2, the legal and regulatory question or changes required to allow for the use of oral fluid testing in the state. 3, how the use of oral fluid testing may impact administrative license suspensions, including whether refusals of them should be used, essentially. 4, the necessary equipment required to implement any program that was suggested, including potential sources of funding. And lastly, 5, additional training requirements that would be needed to implement the program. So at our meetings in general, we did a few things. First, we heard from a number of experts from other states. This included Bill Lindsay, who's a former TSRB for Alabama, which has both a roadside oral fluid testing and an evidential oral fluid testing program. Alabama's DRE coordinator as well joined him. That's Paul Thompson. And Jen Limoges out of New York, who is the deputy director of their state police crime lab, and they use evidential oral fluid testing for their state police. New York also uses, by jurisdiction, some of the roadside oral fluid testing. It's up to the jurisdiction. So she joined us as well. They all presented on their programs and the science behind them and their thoughts and overall opinions on how things are going. We also heard from our own expert with our health and environmental testing laboratory, Ellen Fraser. So thank you to all of those individuals as well. They all donated their time to assist us, and it was very helpful. In addition to hearing from those experts, we had discussions and conversations, how to adapt this to Maine. You know, we saw what some other states were doing. How could we make it fit Maine? And that essentially produced, well, in the end, it produced a vote of 8-1 for the following recommendations. That oral fluid testing be used in the state of Maine for evidentiary purposes. We were specific to the evidential part, that confirmatory testing. That statutory changes that we provided to you in the report, in that Appendix A to it, would be the suggested statutory changes to adopt oral fluid testing. It is generally the original bill that was submitted and sponsored, or submitted by you all, and 2 other changes. So we added 2 other components to it that are detailed in the report. Can get into it if you want to, but essentially they were to close some small items that might have been missed. 3, that properly administered oral fluid tests be used as a basis for administrative license suspensions and refusal suspensions, essentially in the same manner that breath, blood, and urine tests currently are. That, and here's a potential problem, right? That certain equipment would need to be acquired, that being a liquid chromatography tandem mass spectrometer. Yeah, big words there. And oral fluid collection kits. And essentially, the lab would also need 2 new chemists in order to get this up and running and then run the program. That comes at a heavy price tag. The instrument alone, I think, is $700,000. So it is estimated that in the first year, it would be a little over $1 million to implement this, with an ongoing, and I say unadjusted, annual fee of around $340,000. That's salaries, collection kits, and essentially benefits for the 2 chemists. Unadjusted because, as we know, salaries and benefits always increase. And then last recommendation, number 5, Maine Criminal Justice Academy be charged with developing the necessary officer training in coordination with HEDL, the Maine Bureau of Highway Safety, and the Traffic Safety Resource Prosecutors.
Excuse me, could we ask a question?
Absolutely.
Representative Ardell?
Thank you, Madam Chair. You had mentioned some expensive test equipment. Just as an idea, is pre-existing drug tests, laser spectrograph machines, and I'm sorry, I don't remember what they were called.
Yeah.
Are they able to be utilized on saliva? Because I have used them on separate, I've used them on liquids and solids, and their effectiveness and accuracy is extremely high.
Understood. Yeah, great question. Currently, the lab has at least 1, probably 2 gas chromatograph mass spectrometers. These, I'm told, will not be sensitive enough to do the oral fluid testing. So they would need a more sensitive instrument to detect essentially an oral fluid because of the very limited amount of sample you get. It's such a small sample compared to blood, which we typically have much more of.
Please follow up.
Yeah, just a quick follow-up. I just want to make sure that we're talking about the same thing. It's the handheld laser unit
Yeah.
that we use in the field. Maine Drug Enforcement Agency uses it literally daily.
Understood. That is also a screening test. So that is a device. I can't remember the name of it either. I have certainly prosecuted enough drug cases that I understand what you're talking about. We don't get to use that in court to prove what the drug is either. So that those drugs also have to be tested by the lab to be confirmed to be a certain drug. And they use the sort of equipment I'm talking about now.
And I think we're talking about the same thing. However, those field tests were acceptable and used towards probable cause.
They were, yes.
Do you think that could be an acceptable shortcut?
You know, I don't know. I'd never considered that. I do know those tend to focus on, and they are sort of a spectrometer, so you're not wrong. But they are much, how to say this? They're much less sophisticated. They have been used for probable cause. I don't know if they'll test oral fluid. They're not. Certainly the sample of the oral fluid is not designed to go into them, so I don't know. But it's a good question.
And what I'm discussing is the one where you don't place anything inside the machine. It actually uses a laser and can test extremely small quantities of powder or liquid. And I'm sorry, I don't remember the name of the machine as many times as I used it. But anyway, that's something maybe to consider. Thank you.
Thank you. So it would take approximately 2 years from funding to implement this, one of these, because our lab has to go through a process for any testing that gets it sort of for accreditation and approval, as well as to make sure samples are testing appropriately. And that pretty much sums it up. I do need to state that even, you know, in the committee and everyone who presented to it did remind us that oral fluid is not a replacement for blood. There are much less samples, we can detect many less substances in oral fluid than we can detect in blood. It is, however, a good supplement when getting a blood sample is impractical. So this would often, you know, happens when the wardens are in an area that's more remote and can't have to drive 3 hours to get a blood draw, something of that sort, especially nowadays with hospitals being willing to do less and less blood draws. That's basically what we had. I'm open to any questions and let you direct me to where you want to hear more about.
Are there any questions? Please, Representative Hassenfuss.
Thank you, Attorney Salzer. Can you walk us through the current process with the blood draws? What happens now and how this could perhaps supplement that?
Yeah, absolutely. So, okay. Typical OUI risk, okay? I'll just choose a typical one. Where the individual gets into police custody already, okay? So right now we're talking there's already probable cause for OUI. They've been arrested for OUI. They're taken back to a station, okay? Typically, if that station has a breath testing instrument, an intoxilizer, they do submit to an intoxilizer test first, okay? That is to determine if the impairment observed roadside through field sobriety testing or other means is caused by alcohol consumption, essentially. When it appears it's not, when it appears the person is still impaired, even though the alcohol level is essentially below a 0.8, and that the degree of impairment doesn't match their result, okay? A one of two things happen. The standard protocol is to call a drug recognition expert. If a drug recognition expert is available, they come in, they take over the investigation, they put them through an evaluation. If one is not available, the officer, still having probable cause, would then ask the individual to submit to a blood test. Now, constitutional concerns obviously come into play here. A breath test is a valid search incident to arrest, which means it complies with the Fourth Amendment outright, assuming there's probable cause to arrest for OUI, which we've already covered. When it comes to a blood test, the Fourth Amendment kicks in, obviously, with any search, which is any chemical test, any obtaining of a chemical specimen, to be more accurate. And for a blood draw, you need one of three things, essentially, to comply with the Fourth Amendment. You need consent, you need a warrant, or you need exigent circumstances, basically. Those are the three caveats there. So the officer requests the blood draw. If the individual says no, they have the options of attempting to get a warrant. If the individual is physically resistant, even with a warrant, we don't typically force blood draws in Maine. It is constitutionally allowed. Getting the individuals to do it and having the equipment to do it safely is a different question. So it is practically, it doesn't often happen. Only in sort of extreme circumstances would it ever happen. Exigent circumstances, essentially what you all know about is whether, there's sort of an urgency that requires the drawing of the blood. And that blood draw would occur either with the individual officer or after the DRE eval, assuming the DRE thinks there is impairment by drugs. Does that answer it?
Yes, it does. And so for those cases where you don't get consent, then it's just the DRE's testimony. There's no chemical evidence of impairment. You're just going based on, the testimony from the DRE and having the judge decide based on that.
Exactly. And yeah, to follow up, the other part of your question that I forgot about until right now, certainly at that point, if there were oral fluid testing could be offered. I'd still argue you proceed with a refusal case in addition to the oral fluid, but yes.
Are there any other questions? Yes, Representative Ardell.
Thank you, Madam Chair. Just real quick, I remember the name of the unit. It's called the TruNarc.
Yes, that's the one.
And very, very effective. I would be very, very interested to see if there was any testing in which the TruNarc had been tested for use on oral fluid for things such as THC or other drugs besides alcohol.
Yeah, I am certainly not aware that it was. I don't know that hasn't been. I would be interested to know just logically if it can be used, right? I feel like all of these devices that are out there for sale commercially should be those. Yeah. But I'll check.
Are there any other questions? Representative Hassenfuss, question?
Yeah, thank you, Mr. Just given the high cost initially and ongoing of this, I think that, the answer is yes. If it weren't for money, this would be a good program to implement. But to get through that, how often is the current system of having when somebody refuses a blood test, of having a DRE, do the evaluation, go to court, present the expert testimony. How often is that not enough evidence, or does there leave reasonable doubt where the judge or jury says, I think you were probably intoxicated, but I don't know.
Yeah, that is a really good question. And my thoughts and opinions on that might be swayed by the phone call that I got a couple days ago, in which exactly that scenario happened. So it was, an officer calling, actually DRE calling, here's what happened. The case was declined for prosecution because I couldn't get a chemical test, right? I think the problem right now is drug OUIs are proving, even with a DRE, difficult to prove to a jury. There are some wins, there are many losses. So yeah, I understanding the price tag and is this valuable? Without a chemical test, haven't been having the success rate we would hope for. Again, that might be biased by my week that up to this point, but yes, it hasn't. Yeah, that's where we're at.
Yeah, I mean, and part of that I think is the juries expect, like with an OUI case, like what was your number?
Right.
And in drug cases, there is no number to be given. And so does that weigh into, the prosecuting of these cases and the success rate?
I think it does. And I think the drugs that use, not to get too into the weeds, pun intended, but it's certainly a lot easier to get a jury to give a guilty on a fentanyl case than it is a cannabis case, okay? Regardless of any number and regardless of how the person looks in their roadside field sobriety testing. It just is. I don't know why. That is a current fact. I should note that oral fluid testing will not give you a number, okay? It is qualitative, meaning even with the evidentiary, it's just going to say what's there. Only our blood testing program will say, and here's how much. Yeah. And I do think all juries want a number. I mean, everyone wants a number for cannabis. And the fact is the science doesn't support having a number for cannabis, at least at this point.
Are there any other questions? Seeing none, thank you very much.
Thank you all.
Thank you. We're now going to take up LD 2132. Senator Talbot Ross. Welcome.
Very, very much.
Thank you.
You need a copy of the amendment.
You need a copy?
I do.
She needs a copy.
I don't have it. Thank you very much, Representative. Thank you. Good morning. Morning? Morning.
Still morning.
Yeah, Senator Beebe Center, Representative Hassenfuss, and the esteemed members of the Criminal Justice and Public Safety Committee. I first want to thank you for your patience with presenting this bill this morning. My name is Rachel Talbot Ross. I represent Senate District 28, which is part of Portland, part of Cascabay Islands, and includes the University of Southern Maine campus. I am here today to present LD 2132, an act to amend the Maine Emergency Medical Services Act of 1982 to require compliance with the statewide trauma incident registry and make certain technical and other changes on behalf of the Maine Emergency Medical Services. I would like to begin by thanking the Director of Maine EMS, Will O'Neill, who's here today, for providing me with an opportunity to continue to work with him and his team as we try to advance the recommendations of the EMS Blue Ribbon Commission and start to realize the 2035 vision plan of the EMS board. I'm also grateful to Dr. Brian Morse, who is here today, the chair of the EMS State Trauma Prevention and Control Advisory Committee, which, dating back to 1992, has been responsible for developing an organized system of trauma care to reduce morbidity and mortality from the most serious injuries and ensure equality, appropriate care for all other injuries. And lastly, to Sarah Caldwell and Julie Ontengo, who are here today, Katie Fulham Harris, and the team at Maine Health for their contributions to this proposed legislation on behalf of our state's only level 1 trauma center. As this committee knows, after the closing of the CMMC Trauma Center located in Lewiston last December, our state now has just 2 trauma centers, one in Portland, the other in Bangor, a critical problem for discussion at another time. Based on my discussions with these stakeholders for our purposes today, I ask that you direct your attention to the amendment I have offered this morning for further consideration. This bill, in its totality, will do a number of things, but the bill amendment seeks to further address several small but important changes to verbiage in the EMS Act of 1982 and directs the advisory committee to evaluate the development of a collaborative. So specifically, the bill requires emergency medical services educators and emergency medical services training centers to be licensed by the Maine Emergency Medical Services Board. It provides options for injunctive or civil relief for unlicensed practice violations. It amends the definition of regional council to specify that a council is an entity rather than a business entity. Authorizes EMS to convene the State Trauma Prevention and Control Advisory Committee, which actually that's a little off. They are already convening. To evaluate opportunities to enhance Maine's trauma center and opportunities to share uniform quality related data as it relates to injury related incidents. It requires a report from EMS and the advisory committee, which is to include any further recommendations on potential necessary rulemaking, proposed legislation, and funding considerations. That report would be due on or before July 31st, 2027 to the appropriate committee of jurisdiction. We believe that these changes are vital to the future of developing high-quality EMS in our state. By doing so, we align standards for agencies, trainers, and training centers to continue to ensure that patient safety is a priority. We move Maine into compliance with this standard that has been on the books for decades. We complete the transition to the state-supported EMS regional model and allow individual councils to look at their own finances. Additionally, we provide options for injunctive or civil relief for unlicensed practice violations, currently only a criminal penalty. I believe you will hear more about each of these aspects in more detail directly from the EMS director and others who are here with us today following this presentation. I thank you for your time and consideration and ask that you support this bill. I am happy to walk through the bill piece by piece with you if you'd like. While we do have the director here, it is a department bill. But I will just end by saying how proud I am to do any work with our emergency medical services personnel led by the director. It is one of our finest organizations in the state, doing remarkable work each and every day. And through this process, I was able to learn more about our trauma centers and the trauma system that we have here in the state of Maine. And I beg this committee at some point, perhaps in the next legislative session, to really think about the lack of trauma centers in this state and the pressure that it puts on our emergency medical services to accommodate when a trauma center like the one in Lewiston ultimately closes. It is of critical attention, and I hope that this committee will think about that in the near future. Thank you so very much for your time and your consideration and your patience with me today.
Are there questions for Senator Talbot Ross? Yes. Representative Nutting.
Thank you, Madam Chair. Thank you, Senator. Can you explain to us why you chose to amend Section 3 from requiring to allowing? Was that feedback you got or what?
That was at the direction of the emergency medical services, but I think the language switches to intentionally, recklessly, knowingly violating, allowing your license to lapse and still practice. But I think we changed the verbiage to intentionally, recklessly, and knowingly. as opposed to just allow. But that speaks to the intention of having a license either expire and still practice, have it suspended and still practice, or having it revoked and still practice. I hope
Good.
that answers
Thank
your question, Representative.
you.
Are there other questions for the senator? Seeing none?
Thank you all for your
Thank you very
consideration.
much. Is there anyone else that would like to speak in favor of this legislation? Welcome.
Good morning. Senator Beebe Center, Representative Hassenfuss, and distinguished members of the committee. My name is Brian Morse, and I'm the Trauma Medical Director at Maine Health Maine Medical Center in Portland. I'm also the Chairman of the Trauma Advisory Council for the state of Maine. Sorry, I'd like to thank you for the opportunity to testify this morning. I'd like to begin by expressing our gratitude not only to Dr. Talbot Ross, but also, Senator Talbot Ross, get used to saying doctor, but also to Maine EMS for their willingness to listen to the stakeholders and concerns, and also engage in thoughtful decisions on this issue. We come out in strong support of LD 2132 and its current amended status. We are supportive of the sponsors' amendments and believe that it reflects meaningful progress towards a workable and collaborative path forward. We share the goal of advancing high trauma quality care across the state of Maine and also strengthening our statewide trauma system. We're hopeful that continued collaboration among stakeholders as opposed in this legislation will allow us to reach durable solutions that improve care delivery while trying to minimize any administrative and financial burdens on trauma centers and also our critical access hospitals, as well as healthcare systems. As we work towards that shared goal, I'd like to say that as Maine's only level 1 trauma center, we already submit data to a trauma quality improvement project and national trauma database, which are benchmarked databases that we are compared against other trauma centers across the country. One of the things we want to have one of the things we advocate for is a flexible and workable system that really reflects the goals and the needs of all the trauma system hospitals within the state, not just the big trauma centers. We think that the bill as it stands has a lot of positive aspects to it, especially regarding the reporting of data. I think is written in my detailed testimony. You can see that we support the sponsors' amendments, which directs Maine EMS and the Trauma Advisory Council to convene and collectively evaluate the needs for Maine's trauma system to develop, recommend, and endorse evidence-based and evidence-informed next steps for how we create this collaborative. This approach, which is already common in other states, really serves to leverage existing infrastructure, aligns with national best practice, and avoids creation of duplicative and superfluous reporting mechanisms. Although Maine's hospitals continue to face significant challenges, including cybersecurity threats, financial strain, capacity limitations, and workforce limitations, this amendment regarding around this legislation really reflects these realities. The amendment also positions the bill to advance to a system-wide improvements without imposing undue mandates and unfunded mandates. Again, we come out in strong support of 2132 in its current amended and status. And we support Senator Talbot Ross's current amendments, which I think really kind of helps us drive towards this collaborative that we're trying to reach across the state. So thank you for your time and consideration, and I'd be glad to answer any questions that you have.
Are there any questions for Dr. Morse? Seeing none, I'll look for you at our work session.
Okay, thank you very much.
Yeah. Is there anyone else that would like to speak in favor of this legislation, please?
Okay. Sorry for this. I tried to stack them to make it easy.
You ready?
Ready.
Okay.
Good morning. Before I get started, again, I would like to also echo my sincere appreciation for the work of Senator Talbot Ross and more importantly, our statewide trauma hospitals coming together to work with us to talk about a common sense thing that has been honestly stuck on the shelf for quite some time. And we want the ability to be able to provide this important data. So good morning. I'm here today to testify on behalf of Maine Emergency Medical Services Department of Public Safety in support of 2132. My name is Will O'Neill, and I'm the director and supporter of Maine Emergency Medical Services. I'm here to testify, obviously, in strong support of our department bill. There are some very minor changes from the written testimony I provided, and that's because democracy in action meant we were still talking in the hallway right before we came in, which I think is actually very important to this committee to know, because these are real-time discussions that we value each other to have. This legislation initially proposed essential updates to Maine's Emergency Medical Services Act of 1982. The changes that we thought were necessary to ensure completeness of the statewide trauma data and the integrity of our licensing system. The licensing system stands true, but I think we found another solution for the completeness of our statewide trauma data, as you heard in some of the other testimony. Like we talked about, our original intent with the bill was to ensure compliance with trauma reporting to our board as required in statute. We're pleased to report that we are continuing robust discussions with our trauma hospital partners, and we're excited to continue in a work session because I think we have some clear solutions already laid out for us. Intricate and a little bit innovative, but good solutions nonetheless. I want to highlight, although it's a little bit apples to oranges, we've had tremendous success in our cardiac arrest registry, right, which is separate than our trauma arrest or our trauma data registry. Our cardiac arrest registry data reporting and our participation with Emory Hospital in the nationwide data set, including our quality improvement review and recognition of dozens of ENS clinicians and dispatchers for their work on pre-hospital cardiac arrest resuscitation. Unfortunately, our efforts in pre-hospital trauma have not been able to be so robust. Since the current trauma registry's inception as an idea in 1993, Maine EMS and our trauma folks have run into consistent barriers in our efforts to establish a statewide trauma registry or to provide its tremendously valuable link to the National Trauma Database. That's where our partners like NHTSA, CMS, the Centers for Medicaid and Medicare, and others look for data around our state's trauma picture to make decisions, structure project, and provide funding and other resources to state. One of the reasons, and I want to highlight real quickly that it's important that we work together, is because the pre-hospital side of the data, we have a unified data set in MEFRS. Every EMS call in the state goes into one database. So we know an awful lot about trauma already, where it happened, what the injuries we saw were, what the vital signs were. But what we don't have is the second side of that picture that is immensely vital, right? Which is what happened to that patient. Did they get admitted? Were they admitted for a long time? Did they receive blood, ECMO, or transfusion? Did they die after we saw them? Which is a very important question that we're asking as we move into the realm of the national discussion about whole blood and the treatment in a pre-hospital setting of patients with whole blood in our trauma system. So this data is very valuable. We're working together to find a good way to have that data set linked together with that EMS pre-hospital data and our hospital data. So I did want to highlight our cardiac arrest registry. Like I said, it is apples to oranges, but we've done a significant amount of work, and that does what this vision of trauma would, right? Working with Emory Hospital and our cardiac arrest registry allows us to leverage our data against other states, benchmarking for funding with those agencies in a way that this trauma set would do as well. The bill additionally clarifies that entities involved in the delivery and education of emergency medical services are properly vetted and held to professional standards, as the EMS board was directed to do in PL 1999, Chapter 182. Which requires our board to establish by rule requirements for certification and licensing of persons engaged in emergency medical services, education, and training. So to be clear, we currently provide an instructor coordinator license. That's in a rule, and we want to formalize that in a statute in a way that makes sense so that it's very defendable from top to bottom. The bill clarifies the legislature's intent that such licensure is required of emergency medical services educators and our training centers. And this is another portion of our bill that requires larger community support, meaning a work session for a standard definition of EMS instructor. As we built this bill and conferred locally with our EMS education experts, we look nationally to the National Association of EMS Educators and to the National Registry of EMTs. And no one has a standard definition that we can use of EMS educator. So we're going to build that here in Maine through hopefully a work session direction with our community so we can provide it as an amendment to this bill. We're seeking another small technical change to bring our statute in line with other professional boards. Board of Nursing, Board of Medicine, by not only maintaining the existing misdemeanor criminal penalty for unlicensed practice, but allowing us a civil pathway for resolution. I think everyone in the room appreciates there can be a common sense discussion where a series of mistakes happen to someone that led them down a path where now they've committed an infraction, right? What we want is the discretion to administer justice in a way that makes sense, right? For those people who were malicious, purposeful, and practiced without a license, there should be a significant penalty. For those folks that there was some confusion, an injury, some other thing that happened in their life, our board should be able to evaluate those cases individually and decide, is it appropriate to level a penalty at all? And if so, is a civil penalty versus a criminal penalty appropriate? And that's what we're asking to clarify here. Finally, this bill makes a small but important technical change to reflect the nature of our new state-supported four-region model by amending the definition in statute of a regional council to be defined as an entity rather than specifically as a business entity. Recognizing the diverse organizational structure that our current councils may take and how they might want to handle their finances, we'll of course use normal accounting practices and verifications for audits, et cetera. But we wanted to remove that piece because we've had some of our community approaches that say, hey, if we did this as an LLC, if we did this in this structure, if we did this in this way as the council, and our advice from the AAG was repeal this word to make that much easier. So we brought that to y'all. Lastly, and I'll be brief, 2132 implements a bunch of little changes that we need to continue to make necessary EMS, continue to make Maine EMS positioned to provide data-driven improvements to our statewide trauma system, to continue to improve and maintain our high standards for Maine's EMS education and our licensing system. Thank you very much. I'm happy to participate in any work sessions around this bill, and most importantly, here to answer any questions that you may have.
Are there any questions for Director O'Neill? Representative McIntyre?
Thank you, Madam Chair. Thank you, Mr. O'Neill, for being here today before the work session, which it sounds like we're moving towards. Can you give me just a big picture sense of how many instances, without violating any active investigations, a general sense of how many times in this state people have been caught engaging unlicensed practice?
I can. Unlicensed practice is actually something that we deal with regularly enough that we have a delegated order that if it occurs less than 10 times and doesn't incur some other penalty, that we handle that just through a staff delegated order. So it occurs often enough that the board has seen fit to give us the ability to dispose of some cases without even bringing them to them. In other instances, we've seen individuals who have been notified they're practicing without a license who have continued to practice. And again, we're seeing 60, 70, 80 instances of that, in which case we'd see it managed differently. So it does happen. But it's on the agency to kind of keep their eyes on that. It's on us when we get a complaint, but it happens enough that we do have delegated practice for 10 or less of those offenses.
For the work session, can you bring some information, statistics and data with you, say over the last 5 years?
Absolutely.
Is that reasonable? Thank you.
Representative Ardell?
Thank you, Madam Chair. Representative McIntyre asked the exact question
Okay.
that I was going to ask. So I'll refrain from asking it again, Mr. O'Neill. Thank you.
Are there other, yes, Representative Abdi?
Thank you, Madam Chair. My question is just a bit around clarifying. So if someone is caught practicing without, their license is expired, what happens to them as of right now?
So right now we have an EMS complaint process that starts with an agent and a complaint being registered, right? And then that agent who's clear certified, which allows them kind of a law enforcement level certification to submit subpoenas, request information and do interviews, then conducts a binder of investigation. That binder of investigation is then submitted through the EMS licensing board, where they review the complaint against the actions they can take potentially against someone's license, up to and including revocation of a license, or even the emergency revocation of a license. Did I answer your question?
How often is that one? And how long have the license expired for consideration?
It does, and again, that's one of the reasons that we really wanted to have a common sense rule that allows us to kind of look at individual situations and say, what happened here? If you were hospitalized for 3 months and your EMS license expired while that happened, that seems like a common sense discussion we could have with our board about how that isn't an infraction in the same way as someone who got a letter and received it and then practiced for 3 more months. And I think that everyone kind of appreciates that difference. So thank you, ma'am.
Are there other questions? Yes, Representative Bunker.
Thank you. Thank you for being here. Help me understand in looking at the LD itself on license required and civil and criminal penalties that are proposed by statute. Are these penalties new, or have they been dealt with by rule and now you're putting in statute?
So there is a portion that's already in statute up to a $1,500 penalty, and there are portions in rule. This is kind of, again, we're using this bill as a cleanup of some things that we saw as technical changes necessary to get those things in line and to provide that civil and criminal penalty piece.
Okay. My familiarity with your work is very basic, and it goes to the emergency medical dispatching world itself, which we've had long-term licensure through your office. I see in section 1 on license required, this seems to add EMS educators and EMS training centers.
Correct.
Are the folks who educate dispatchers in emergency medical practices and the center that they teach in fit in this, or was not intended to include them?
That's one of the reasons that we like to kind of sit together as expertise. Our original take on that, and in talking in our office with our EMD liaison who works closely with the CVS kind of across, what we saw was that their process is very specific. It's an international association of emergency dispatchers. You will know, Representative, but for others, essentially they have a set standardized training that every one of them takes, and then they just apply for us to keep current their licenses. And so in terms of providing their training, tracking their training and doing other things, they're really a very, I'd say, easy group to manage in that sense. So they're kind of standalone and we don't anticipate we're going to have to make changes to any of those definitions. But we did not want this bill to unintentionally make changes to that, which is part of why we wanted a little more time to confer with expertise around that. In deference and not to be long-winded, but even in places like our island communities where we'll have doctors and nurses show up for short periods of time, we'll do summer and say, hey, I would like to teach an EMT class in advanced radiography XYZ. That person shouldn't have to be trained and certified as an EMS instructor. They're clearly qualified to provide that content. But what we want is for folks that is consistently what they do, and that is consistently how they hold themselves up, that we're able to regulate them and keep them to the quality standards that the rules already require. It's kind of what that's for.
Thank you.
Thank you.
Are there other questions? Seeing none, see you at the work session.
Thank you all very much.
Online, we have, I beg your pardon? Is there anyone else present who's in favor of this legislation?
Okay, no.
Okay.
Sorry.
That's all right. Amy Fenwick?
Yes.
Okay. Is her camera on?
She's been, but soon as I want to respond to my text with her. My first change, I've got a woman that wants to know. Soon, She can speak if she has views, but we can't see her.
Okay.
Okay. Yes, she called me, Amy.
Oh, it's talking to him?
Yes.
Okay.
She just has to unmute. Okay. Totally from the mom. This, do you want to ask her to Amy's?
Amy, can you please unmute? She's gonna unmute. It's not working? What?
Okay, she's unmuted now. But we can't see her because this is one.
Okay, so apparently we're not going to be able to see her, but we will be able to hear her. Amy, would you like to begin? Maybe? No.
It says she's unmuted.
I can hear you on the phone, but we can hear through the computer.
Let me.
Oh, yeah, that was.
Oh.
I can get her phone number.
She has written testimony, actually.
She said it's not working.
It's not working?
Does she
Okay.
have written testimony that
Yeah,
she's?
yeah, it's,
We can.
would you like to read her?
No, we can read.
We don't have it yet, it just came in, but if you'd like to.
I think it's, I mean, we all.
Do you want to read it?
I think once we all get it, we'll be able to read it. It's just one paragraph saying that. The trauma medical director of Northern Light Eastern Maine Medical Center supports this bill.
Senator Talbot Ross, did you want to say something?
Thank you, Senator Beebe Center. I believe that the person who would like to have their testimony read into the record, if it's possible, we would have someone read it. I could read it. But out of due respect, she did want it read into the record.
Yep.
That's it just came.
It's quite short.
It is. Thank you.
So, good afternoon, Senator Beebe Center, Representative Hassenfuss, and esteemed members of the Criminal Justice Public Safety Committee. I am reading the testimony on behalf of Amy Fenwick in support of LD 2132. As the Trauma Medical Director for Northern Light Eastern Maine Medical Center, I support this bill and appreciate the work of all involved to make this a viable path for trauma care in the state of Maine. Thank you for your time and attention to this bill. And unfortunately, she's not here to answer any questions, but we appreciate your willingness to hear her testimony this afternoon.
And possibly she'll be able to make it to the work session.
I can certainly ask. Thank you, Senator. Thank you,
Okay,
Representative.
thank you. Is there anyone else that would like to speak in favor of this legislation? Is there anyone that would like to speak against this legislation? Is there anyone that would like to speak neither for nor against this legislation? That's the end of this public hearing, and we'll schedule the work session. Thank you very much. So what we're going to do is we're going to take, why don't we say half an hour, which would be 10 minutes over. Beg your pardon?
Scheduled for 1 o'clock.
Oh, I thought it was 12:30.
Is it 1 or 12:30?
I thought it was 12:30.
Oh, I'm sorry, but no.
It's work session.
12:30, it's scheduled for 12:30.
I mean, we were scheduled to start at 9:30, so I feel like.
Okay, so we will start at 12:40. And would you take a half hour for lunch and break, and then we'll come back for 4 work sessions.
And Democrats, can we grab a little bit of food and then caucus in the office in 10 minutes?
10 minutes?
15 minutes? There's food over there.
Oh, where?
Right.
Turn your mic off.
Yeah, no, I was.
That's what I figured.
There was
Let me know when you're ready. You ready?
We're ready now. So there's been a change in the agenda. What we're going to do is we're going to hold the 4 work session bills until judiciary acts on 1911, and we have that information. And we're going to go through with Will all the different committee bills from the last presentation of the series of bills. And we're also going to take a vote on the oral fluid report that we had this morning. We're going to propose that we vote on that.
If I might, that bill that generated that report was Senator Shearway's bill. I'd prefer
so we'll
to wait until he's
problem.
having some difficulty with a vehicle today or something.
No, we'll wait on that. So we're going to do, Will's going to lead us through the committee bills, and then we're actually going to adjourn.
Thank you, Madam Chair. Okay, so the document you have in front of you at the top is titled Reports and Repealers. It's just an Excel sheet with all of the committee bills. Not only that were created last session, but that are on a periodic basis, annual basis, et cetera. We're going to break this up into a couple parts. One, we're going to focus on report backs, particularly recent ones, where the committee has authorization to report out a committee bill. There are a number of bills or reports that we have not received yet. Or at least I don't believe we have received, because just to be clear, reports come to the committee in a variety of different ways. Sometimes they are emailed directly to me. Sometimes they're emailed to Bernice. Sometimes they're emailed directly to committee members, or there's also a separate committee email that I think Bernice has control over, right? The committee's CJPS email. So there's a couple of avenues that we get these reports through. So at least from my understanding and Bernice's, I don't believe these are the ones that we have received, but just there's a possibility that I could be wrong on these. So we'll just go through these in order, starting with the Board of Visitors report. This was based off of LD 1725 from the first regular session last year. That reported each county sheriff to report regarding the status of the Board of Visitors vacancies for each jail or other county correctional facility that is under the sheriff's supervision. So to my knowledge, I don't believe we have received any reports regarding the composition of those Board of Visitors or the issues that they're facing in terms of filling those vacancies. Again, I don't know the reason as to any of these reports as to why they haven't been received, but I think the idea here is there are about 12 reports in general where we have authority to report a committee bill, and about half of them have not been received. So I think this is really an open discussion for the committee in terms of where is the committee going to set its priorities in terms of which of these reports are we going to follow up on.
Okay. Shall we go through in order and see what people's thoughts are?
Okay.
Shall we start with Board of Visitors?
Yep. So I mean, to that point, oh, sorry.
I'm just thinking as a rule, if we have a report that we've not received, can we just say, request our analysts to reach out and say, hey, we need this report, or what's going on, inquire about it and ask. And for all of them that have not received, then I would suggest just skipping over.
Yep.
Is there anything else we need to do? Or
Okay.
that we want to do? For all of them?
Okay, so all of the ones we haven't received, we can make a single motion on. Yes, Representative McIntyre?
I agree with Senator Curry, and I hope that we properly empower Will to use the full weight and measure of this committee and not leave him hanging.
Yeah.
So however you phrase it, make sure that they understand we as a committee are behind you in your request.
Joe, you good with that, Will?
Yes, and I will obviously provide the committee with an idea of that letter. Obviously, each one will be a little bit different because it's going to different entities, but the language will generally be the same in terms of, what the committee is asking for and what we haven't received.
Okay, sure.
But I will run that by the committee, of course, before it gets sent out. So to that extent, in terms of the reports that the committee hasn't received, I think that's fairly easy then if we don't need to go line by line through each report. But I will point as well to, we've had several reports that the committee has received. Sorry. That we did not take a vote on regarding whether we wanted to create a committee bill based on the report.
Okay.
So the first one that would be is the earned time credits report from the Department of Corrections. Unfortunately, I don't recall the report actually including any suggested legislation. It was more of an informational report.
Okay.
And then the second one would have been the county corrections report that we obviously just received. They were waiting to hear if there was an addition in the supplemental budget for a county jail funding. I don't believe that was included in the supplemental budget. So they did include in their report an appendix regarding increased county jail funding. And then last we had obviously the oral fluid testing today, but I understand that was Senator Searway's bill, so maybe the committee wants to hold off on discussing that.
Yes.
Thank you, Madam Chair. Thank you, Will. The earned time credit report that we received from the Department of Corrections listed a number of agencies as stakeholders that participated in that report who didn't actually participate in that report. Is there any mechanism that this committee has to request that they actually do the work we task them with doing before determining whether or not we want to report out a bill?
Sorry, can you rephrase that for me?
Yes. So when the Department of Corrections presented their report based on Representative Sargent's bill, I forgot the bill number off the top of my head, 1979. The language that we had in that resolve required that the Department of Corrections pull together a group of stakeholders, which I think were specifically listed in the bill. And when the Department of Corrections presented it, they presented it as if they had engaged those organizations, but they hadn't in fact done that. They had just put together a bill or a report themselves and then listed agencies as having participated.
Yeah.
So because they didn't actually fulfill the obligations that we tasked them with in the law that we passed, the resolve that we passed in the first session, is it possible to make a request that they actually do the work we asked them to do?
Yeah, so basically saying like an amended version of that original report and then specifying this needs to be done. These invited people need to be in person and included in every meeting, something along those
There may
lines.
have been recommendations made by that stakeholder group had there actually been a stakeholder group, and that would have been helpful.
Yeah, that's definitely a possibility that we could do a committee build, basically redirecting that work for better inclusion, obviously, of working group members.
And are you comfortable putting that together?
Yeah, if the committee is interested, I mean, we would, it would go through a regular process again of, it technically doesn't have to come back to committee. I mean, it could be reported out to the floor if the committee is comfortable, since it's something that we've already discussed. Otherwise, it would go back through the regular process of, I would create a committee bill, we'd have public hearings on it again, and then a work session to vote out. So it would go through those processes again, unless we want to report it out directly to the floor.
What would the committee like? Yes, please.
Thank you, Madam Chair. So would it be reasonable to just say, like, make a motion to basically pass the same language we already passed in the first session?
So we would need the vehicle, so we would have to create a bill unless we had some other current bill that we had. We could do it through that instead, but we would need an actual, a bill to do it through. So we could create a committee bill.
So I guess my question is, since this provides us a mechanism to report out legislation for the second regular session, is it reasonable to say, have that legislation be
redirected?
Basically the same
so
bill we had the first session?
Yes, so we would do a motion to create a committee bill with that committee bill having that redirecting essentially the substance from the first one. Yes.
I would, I would like to just hear from other members of the committee about how they feel about that.
Are there other thoughts on that? Representative Hassenfuss?
Representative Milliken, how would you feel, perhaps instead of going through the committee bill process of a letter or a request from the committee to make an addendum to the report to include, so we're not having a whole new bill with a whole new resolve. And of course, it wouldn't have the full force of, law as what the resolves have, but it would have the desire of this committee to make sure that the intent of that law that was passed is fully honored, and a hope that they would take the time to do that, make that addendum to the report.
Representative Milliken?
Thank you. I would be very open to that because it doesn't seem like bills we're passing this committee have the full force of law if they're not required to comply with those. So I think that would be reasonable.
So are we good? We good
Yeah,
with
and
that?
so just to clarify that, you mentioned an addendum to it, but it would mostly, I think how that would take form would be a letter to them basically explaining, here, we've modified it. Please go and do this again. Okay, just wanted to make clear for addendum purposes.
Yeah, it would essentially be saying, you know, we're disappointed that you didn't include this. Can you please?
Yeah.
Senator Curry?
Well, I would like them to explain their efforts to include those other, I'd like a description of how those other parties were included or were not included, or what, and then if they were not included, to seek out to include them, to then make the addendum. I think the first part is they've got to be able to respond to the challenge that they didn't include anyone, or how they attempted to. But so something in the letter that says, describe what you did. Did you do it? And if you were not able to bring them in, we'd like you to do that. And then making an addendum or addendum to their report.
And they did briefly touch on it during the presentation as if I remember correctly from the Department of Corrections, and hopefully I don't misstate it, was that I think given the short time period, they said that they had difficulties assembling the group, and that their version of convening a working group was, I believe, an email was sent out to members near the finalization of the report. And they asked for those members' input on it. But my recollection was the basis was that they just didn't have enough time. Then of course we can still get the Department of Corrections to affirm that statement in a letter as well.
So you're Representative Milliken?
Sorry, we might also ask the agencies that were included in the list that didn't have a chance to weigh in.
Okay.
So Will, you're clear what you need to do, right?
Yes.
Perfect.
I think
Any other thoughts on that from people? Yes. Representative
So
Nutting?
we're gonna just say that according to what we know now, they missed the boat on some of the input. And we wish they wouldn't do that again, but it's too late to move this forward and produce a bill, even if we liked it almost, isn't it? Yeah.
Yeah, so they would be providing a report to us. The current committee bill, the current resolve authorized us for legislation for this year. So I assume that they, will not be able to produce anything meaningful in the amount of time left in this session. So it is something that we'd receive in the 133rd. So in terms of authorization for reporting out a bill, then we would need to create a committee bill giving a specific authorization. Otherwise, we would just ask for permission from the presiding officers to create a bill. That would be the primary mechanism. Or if we already have a bill, say in the 133rd legislature, you can use that as a vehicle for whatever their report is, attach it to one of those LDs. So there's a couple of options for it.
Representative Hassenfuss?
And I would think, given it being the first session of the 133rd, if that report is satisfactory completed, any member could then use that to submit a new bill request when, bills are not limited. So I don't think we need the ability of a committee bill. I'm not sure we can even do that through a letter. I don't believe we can, but so I think just as long as they understand that we are not happy that they did not give best efforts to due diligence, and best efforts. I know there's a legal term I'm looking for here, but I can't find it offhand, that we're, disappointed and hope that they can rectify that with giving us that additional information.
Good faith effort, maybe?
Was that?
Good faith effort?
Good faith.
Good faith?
That's what I was looking for.
So Will, you're fine with the wording for this?
So I'll still come up with the wording and it'll be.
Okay,
the committee
bring
will
it to
review
us.
Yeah.
Okay. Representative Milliken?
Yeah, just to make, sorry, Will. To get us maybe the report back with a good amount of time before cloture.
Yeah.
Representative Cotter? McIntyre.
Thank you, Madam Chair. I think I'm tracking what Representative Milliken is indicating. It needs to be time bound. They need to have a hard deadline.
Yeah.
For a report back. Otherwise, we're just going to set ourselves up for the kicking the can.
Sure. So have we finished with that bill?
Do we need to vote that one?
Do we need to vote on this?
I think, yeah.
Okay.
Just show of hands, I think would be appropriate. So anybody who's in favor of the letter, or if the committee feels more comfortable, I could take a first stab at the letter. We can review the letter and then vote then, either way.
What would people like? Yes. Representative Bunker.
We'll go with a letter. Rules.
Okay. Yes, Representative McIntyre.
Friendly amendment. I would like to make a motion that for this line item, we'll write a letter, a directive letter that we get a chance to review and we forego taking advantage of reporting out a new piece of legislation. That's my motion. Is that
Okay.
understood?
Is there a second? Second?
Yeah.
Any discussion? All those in favor?
Okay.
Any opposed? None opposed. Okay.
That's great.
Okay, so that took care of the first of 50 bills.
Well,
Sort of.
Sort
of.
Yeah, at least reports received that we are working on committee bills. Okay, so we are holding off on oral fluid testing for now.
Yep.
Oh, county and regional jail funding. That will be on page 2, second from the bottom. So as you know, we already did receive a report on this. We had the presentation. We just didn't vote at that time, but.
Representative Hassenfuss?
Thank you, Madam Chair. I would like to authorize a committee bill for this. And I would like to have two parts. One is a funding piece. I think for your drafting purposes, Will, we could just draft it at the rate of inflation based on the initial 20,000. I can't remember what the percentage was, but the initial percentage, 20%, I think, or 20. Just for your initial number for the bill, it could be 20% of, was it the corrections budget or?
Yes. Jail fund.
The jail fund.
Of the jail, so the.
Yeah, so there was a number in the report. Do you want to go just with the number that they provided? Or
Yeah.
did you have issues with it?
Yeah, go with the number there.
Okay.
Knowing that we can always amend this.
Yeah, we
and
can change it in work
write it
session.
down, but so one is a funding allocation. The other piece is I also would like some unallocated resolve language directing the jails, county commissioners, Department of Corrections to sort of review whether jails can be regionalized, whether the state can take responsibility for certain arrestees, certain residents, things of that nature, sort of going back to the old proposal of, can the state sort of take more responsibility over county jail operations, try to get all the stakeholders involved in that and continue that discussion.
Okay. Is this the really the idea of the Professional Standards Council or even beyond them?
No, I think it'd be beyond that. It would be like looking to see the feasibility of sort of changing the structure. So instead of 16 counties running 15 jails, perhaps.
No, I just mean in terms of like membership of this working group.
Yeah, I
that
think-
that could encompass a lot of folks.
I think that membership, I mean, you would need sheriffs, you would need DOC, you would need county commissioners. I think if you brought that group together, that would be worthwhile. Once again, this is the draft bill that then would go through the full committee process of public hearings and work sessions and stuff,
Yeah.
but just.
Senator Curry?
I'm curious if within that you're comfortable with like the charge around regionalization is to create a funding system that incentivizes regionalization, or to consider a funding strategy that incentivizes regionalization.
Yeah, I think that'd be fine. I think as many ideas.
Cost effectiveness
Yeah.
and something like that.
Like, let's get the ideas on the table, see what we have for public hearing, and then see if through a work session, we can come up with something that works, knowing that if we don't like that idea, we have the funding allocation and. people just
Are there
saying,
other thoughts? Yes.
Thank you, Madam Chair.
Representative.
History lesson for me. This discussion about centralization, consolidation, jails, prisons. When did this last occur? I believe it was during the Governor LePage administration. Does that ring? Okay, so is that report still accessible? I mean, because I understand what you're driving at, and it's gonna lead to spirited debate, I'm sure. But if we have, in order to help Will, I think you're proposing a revisit to previous work group or whatever it was called at the time with up-to-date focus points.
Yeah.
Oh, that's me.
Yeah, I think that'd be fine. I think however we want to word that, if,
I'll try to look into this.
Chip, do you want to clarify any of this?
I think that makes sense. I mean, included in the charge to this could be to review the history of regionalization efforts and to recommend strategies that save, are cost effective and that's continuing on. I think all that makes sense.
Will, are you comfortable with this?
Yeah, and we'll probably go through a little bit of a different process on this one. There are some committee bills that we receive that are very straightforward, like a small change, like the fire marshal's office bill that we had. I received that, I submit it to the revisor's office, and then it comes back for a public hearing. This one will probably have like an intermediate step where we're going to review that language before we create a committee bill, because that'll definitely be a topic where we want to get the most valuable public hearing feedback that we can get. So we don't want it to have I'm sure it will be subject to plenty of changes, but at least we want to get it as close as possible as to what the committee's thoughts are prior to that. So we will definitely review that prior to a committee bill being submitted.
So you're comfortable doing the first
Yeah.
hit? Okay. All right. Representative Bunker?
I don't want to be the pessimist on this topic, but I've chased this for years. Way back in my youth, I was executive director for the Sheriff's Association. And so I've gotten a long history of the corrections aspect of this. I think, I don't want to sound negative, but mixing that group of stakeholders together to come out with a solution is going to be like oil and vinegar. I'm afraid on that.
Sure.
I would like to look forward to a third-party independent review. I hesitate to use the word consultant, but look at a state of the states as it relates to corrections to try to bring that model back. Use those stakeholder groups around the table. But I'd love some fresh ideas, because we've been down this trail of regionalization.
We have.
Before. Corrections has got one strong view, sheriffs have got another strong view, and I'm not wondering without additional input somewhere, we're not going to get a lot out of it.
So Representative Ardell?
Thank you, Madam Chair. Just to briefly add to that, I mean, we have a couple or three counties that are practically regions in and of themselves, to include Aroostook, Washington, and Piscataquis. So, it's sort of incentivizing regionalization across the board is maybe not a smart move.
Okay.
It's not a one fit for everyone. And then the other one is we really need to address who's going to pay for the medically assisted training and then medical treatment generally. I mean, I think those as two major pieces of the jail budgets. It's, if the state mandates these things, 85% of the things that happen in the jail, but only fund 20%.
Yeah.
That's, I mean, I see that as a major part of the problem as well. So
Senator Curry?
Yeah, I think all of these are very real concerns. I'm wondering if we're comfortable just getting it back and then having this debate when the committee is when we have either language that you bring forward to us or once it comes back and doing it at that point. I think we're all circling around the same issue. And I fully agree with you on your concern. Aroostook is a region. You know, I wouldn't want them to be penalized for, you know, because they're not partnering with York.
Representative LaJoy?
I agree. I agree with Representative Bunker and Odell, as well as the good senator. I came in, my first term in here was the last term of Governor Baldacci, where he basically came up with a basic plan. And I think even Representative Nutting might have been there at the time. I'm not sure.
Probably was.
Yeah, and when they presented that particular plan, I said to myself, this is not going to work. And I was there for the next 7 years and it didn't work.
Yep.
And
Yep.
it's still not working today.
Yep.
So I agree with the independent, study
Sure.
to move that forward, and as well as what Representative Waddell. Some counties cannot meet that. And what do you do then? So thank you. I appreciate it.
Will?
So I mean, Senator Curry's right too. I mean, there will be something drafted and maybe we can have a more robust discussion at that point as well. Part of the independence about what goes into this original first draft that is reviewed by the committee is, I don't know if you foresee that as something that is done by somebody in the state that is doing it for free, which would be amazing. But once you implement something like that, there's probably going to be a fiscal attached to it, which will obviously affect its ability to move through the legislature. So just something to consider.
Okay. Senator Curry?
Apologies for speaking so many times. But I'm wondering if
We haven't seen you for months.
Yeah, I'm getting it all in. Pick it up. That's right. I'm wondering about like what we're trying to do with EMS and what we're trying in terms of like for those who are trying to regionalize, those who are struggling with affording their jails, maybe the study is not about the whole state, but how do we support those who are trying to figure it out? Like, are there structures? Are there tools? Is there funding for like a grant program to help counties that are struggling to figure out, or model partnerships? Is there something that's less about we're going to create the structure that requires you or incentivize you or gives you a carrot to regionalize, or maybe it's like you're trying to figure this out and we're going to have tools and resources to help you figure it out? Is that a better way to go?
Yes. Representative LaJoy?
Would the law library have information on that with regards as to that complete study and or the efforts?
Are you referring to
Downstairs library?
Yeah, are you referring to when the attempt was made in previous
Yes.
administrations?
Yes.
Yeah, it is definitely something that I can look into in terms of what led up to that, because I thought it was out of thin air. There's probably studies where
Absolutely. Thank you.
product created to, yeah.
So you're comfortable doing this? Will?
Yes.
Okay. Yes, Representative Perkins.
Thank you, Madam Chair. I just want to make one comment, and I like what Senator Curry just said, more than offering an incentive to regionalize, because operationally, someone who has had to take a hour-long drive to take somebody to a jail after being arrested, and to be clear, we made every effort we could to bail somebody out at the department when we could. But there were some people, because they were a dangerous community or because of a warrant, whatever, we had to take them to the jail. And when you have two officers covering a town, because we're getting 40 calls a shift or 50 calls a shift, and you have to take one of those people an hour away to take somebody to a jail, and then they've got 20 minutes of in processing and then the travel back, that other officer is left there without backup. So operationally, it's a real burden on some of these towns, and it's it's an officer safety issue. And then when we started talking about regionalization, we're talking a further distance.
Mhm.
You know, a lot of these towns, it would, you know, departments that are having it hard enough, we can't hire officers. And this was back, you know, a couple of years ago when I was working, and now we have fewer and fewer officers. So I would not be in favor of something incentivizing people to regionalize, but as Senator Curry said, hey, maybe if regionalization works for you and it's not a serious impediment to your officer safety or your logistics, and we can help you fund your jails better, I would be okay with that. But I'm not in favor of incentivizing people to regionalize simply for monetary value, because I don't think that takes into full scope the practicality of operational necessity.
Okay, okay. Are we good with this? We'll look at what Will comes up
Yeah,
with.
so one of the things, do you maybe want do you want to split this up, two committee bills? I mean, the funding component and then this resolve? I don't know if these will get tangled up with one another or.
Yes, if we can split them up.
Yeah.
Let's do that.
Okay.
Representative Milliken?
I was just gonna point out that Representative Ducharme has a bill that's on the appropriations table. Or apparently not. So.
Do you know that LD off the top of your head? Okay.
It was the one that we had in this committee previously. We voted out. It's the just a funding allocation for county jails.
So are we good?
Yep.
Okay. Next one?
So that covers reports that we have received and had a presentation on, but not reported out a bill. Regarding the bills that we've not received, we've already discussed that, reports rather. I will draft a general form letter for all of your review before those are sent out.
All right.
Everything after page 3, so 4 through 8, these are different types of bills regarding a lot of annual reports. Some of them are very old. There is one that I specifically want to point to on page 5. This was regarding LD 405, which I think was Representative Lookner's bill, the prisoner segregation bill. As part of that, we had required that the department report information for each correctional facility that included information about prisoners who have been segregated and not allowed to leave their cells. So that was something that was supposed to be annual, not just a one-time report. That was a statutory change. That was starting in 2026 with the first one January 15th. It might be the case on that one that the department is bundling that one with their annual reports. So I don't know if that one's necessarily intentional, but I mean, still that can just fall under the same category of a letter of, do we have an update on this? Where is it? But I just wanted to point that one out because obviously that was something very recent we did as well.
Okay. Oh, I'm sorry. Representative Lookner?
Thanks, Madam Chair. I'm just a little bit concerned that this is, something we haven't heard anything and we're past, that statutory deadline. So I think we're maybe dragging our feet a little bit, and I'm wondering, when we can expect some results, because there should have been more than adequate time for them to collect that data and give it to us.
Is there language you can put into these requests and these statements?
So these
and
will,
requests?
if you don't, I mean, it's tough. We'll have to see the general letter that I'll be sending to all of the entities that haven't submitted a report yet. If we think that there is specific additional language that would be warranted for some situations, that's something that the committee we could accomplish, but I would generally be asking as well, please give us an update on this. This was due to us January 15th, submitted as soon as possible. But if you want something on top of that, then that's something that we can discuss once I kind of provide the general letter to the committee of what that would look like. So.
Would that work for people? Okay. All right.
So regarding the remainder of these, there's about 70 reports in general, I think the committee receives. I'm not able to track down, as I mentioned earlier, sometimes reports come to me, sometimes they go to Bernice, sometimes they might go to specific committee members or the chairs. So if there's, and Representative Hassenfuss and I discussed this prior, if there's a specific report in here that you have not seen yet, that you're interested on the status of, have we received it? If not, if you have further interest in tracking that down, I believe we would ask you to reach out to the chairs first. And then that can be a point of further discussion. But there's quite a few in here, so we want to give you guys time, committee members, time to review these and see what you're interested in, rather than going through all 70 right now, trying to figure out.
Representative Bunker?
Am I seeing a duplication? The very first one on page 1 is one business county.
Yeah.
And then on page 6, the third one down is board of visitors.
Yeah, so they're two separate ones. The one on page 6 is just referring to the general inquiries we received from the Board of Visitors themselves. The one on page 1 was the one-time report about the Board of Visitors not being fully staffed or meeting the statutory requirements for who is supposed to be on the board. So they're two separate reports. This was just a one-time report on page 1.
Can I add? No.
Yep, Bernice has something.
I just want to say, I've forwarded, I have hard copies of all of them regardless of their length in the master file in the reports drawer. I haven't printed up ones that are a lot of pages for each member. I've just emailed them on to you, but I'm always happy if you request to print up a copy for you and either give it to you or put it in your report folder.
Okay, thank you.
Yep.
Thank you. Representative Bunker?
On which of these I've actually been. I lost track. Some of these, I thought, yes, I remember that one. Some of these, that I'm embarrassed to find this one. It's got to be some of them.
There are a lot, and they come to us in many different formats. So.
Yep. Okay. Representative Milken?
Thank
You
you,
have a
Madam.
question?
Oh, I don't have a question. I'm just thinking some of these might, like, many of these are annual reports that have probably been required for some time, and it
Since
might.
before I was born on some of them.
It might
Yes.
be worthwhile for the committee to look over which ones we aren't consistently reading as a group and see if they're still necessary, especially since some of them are not being submitted anyway. Maybe we might consider removing some of these from requirement, just a thought.
Any response to that thought? Representative McIntyre?
I second that motion. If
Okay.
if there is cumbersome administrative burden on these agencies that is potentially detracting them from meeting current deadlines on more exigent, good on you.
It might be worthwhile to take some time and think about which one, like, I don't know that I want to make a motion right now to remove any of them, especially given that I don't know the history of pre-Will's birth. Since he's so much older, no, I'm just kidding. But I just think as a committee, we might consider ways to remove some of these from our workload.
Representative Hassenfuss?
I agree with both of those, and I made the suggestion to Will that committee members review this sheet. If there's any reports that that are outstanding, that they would like to have a committee letter sent to get that report going. I think we're more than happy to do that and I concur that if there are some reports that the committee feels like, you know what, this is just outdated, we don't need to do this anymore. Because we want the reports on the books that this committee expects to see every year. And if we don't care to see it, then let's clean that up. So I think if everybody just takes a little bit, goes through here, digest what reports are important for them, maybe not important for them, we can then have a discussion on, what letters to send and, what reports maybe we make some amendments to.
Representative Milliken?
Thank you, Madam Chair. Thank you, Representative Hassenfuss. Words are hard this afternoon. Well, would it be too much work, and you can feel free to say yes, to find out when these reports started to be, like, if they're coming from, the 80s, it might be nice to have that, and also know when they were last submitted if they haven't been, you know what I mean? Is it on there?
There are some.
Oh, okay.
There are some.
Some of them don't have the year, so like on the
2026.
many of them don't have the year, and I can take the time and go through and look at them, but it just might be helpful if we all had that information.
Yeah.
And then especially if they haven't been submitted and, you know, if they came into effect in 1990 and we haven't received one since 1997, that might weigh heavily on whether or not we decide we still need that report.
Yeah, I think in terms of getting the dates, I don't think that would be too troublesome. I mean, obviously the citation will be in statute, but it's possible that it could have been amended many times, but it should have the date that it was, you know, introduced or enacted rather. The last time the committee has received the report will be a bigger, I mean, I'm happy to do that. I think it will take more time and probably be something over the interim that I would do. But at least getting the dates on these of when they were first introduced, I think is manageable.
I would be okay with, like, I don't know that I'm needing that, you know, imminently or anytime.
Right.
in the future, but happy to wait till the 133rd or whatever.
Okay.
Thank you, Will. Thank you. Representative Hassenfuss?
I wonder if it might make your life easier, Will, on that. If you just contact, I know a lot of these are, you know, Department of Corrections or MCJ. If you just said, what are the reports that you're just not doing anymore?
Yeah.
And, you know, can you articulate why? And then, you know, the committee may just, may agree that, yeah, you don't really need to do those. Let's cut those out and just focus on the ones that we do actually want you to do. So that may be another avenue for you to actually talk to the departments themselves and say, what ones just are no longer relevant, what ones are.
Yeah.
Like we are asking very firmly and nicely for you to submit the reports that are legally required of you, but at the same time, we understand that there's some that are just outdated. And so let's clean that up so you don't have a legal obligation to report stuff that is irrelevant.
Senator Curry?
I would not, for the ones that we know that we're expecting and they haven't turned in, then I'm very happy with the letter to say this is law and you need to do this. For all those ones that we're not really sure about, I would hope that we would ask you to do that after the session. I mean, it doesn't seem like the highest priority.
Yeah.
I'd love to hear over the interim that, oh, these departments haven't done it in 10 years and nobody noticed and nobody seemed to miss it. Maybe that's a good indicator that we can say, oh, you don't need to do it.
Are you okay organizing that?
Yeah, I think that makes sense.
Okay.
Especially with the time constraints too of the immediate report backs that we were supposed to receive. We're on a tight time schedule of receiving those reports and creating committee bills. I mean, we were really supposed to have them basically this week. So I think that makes sense of kind of dividing it up into two parts of here's the ones we were supposed to receive. Please let us know what's going on when we expect to receive them. And then something separate down the line, right? Of let's talk about which bills we haven't received long term that we can maybe try to flesh out as a committee what we need to receive and what can maybe be written of.
I think that's sensible. I think that makes sense. Representative Hassenfuss?
Yeah, and on that point, are there bills here that we've recently enacted that committee members feel there's an urgency to receive information from? Senator Curry, I'm looking at you for the island communities one. I do feel like the tribal law enforcement officers training is something that we probably need back so we can figure out if there's a path forward here. And there's a few others. So I think if there's any urgency in these, speak up today.
Representative Perkins?
And regarding the tribal officer one, I think they've resolved that. I think that's already been taken care of. So that's something like we might want to check into, but I believe there's been a solution found for that.
Yeah. And if there is, that's great, but it's just like, let's know so we know that we don't need to do anything further on that.
Representative Bunker?
All right. Representative Perkins, I think you're right. I think the Academy trustees got that resolved, but I haven't heard back what that one is, and I don't think it would need a statutory change, but it's worth asking on that one. The fire sprinkler system plan with fire marshal granting secondary agencies permission to do that under his guidance, that report back came positive. And I bet if we asked our good fire marshal, he could come back and say, yes, piece of legislation would look like this. That would be a pretty quick one.
Okay.
We have the committee bill already. For
Representative
You've got it
Hassenfuss?
all ready for it?
That's in processing right now.
Perfect.
So we
Okay.
should see it in a week or two.
So, Will, that's quite a list of things to do. You're comfortable with it?
Yeah.
Okay, all right. Any other
Sorry,
Representative
the
Milliken?
the segregation one from MDOC would be helpful as well. And I know Grayson, sorry, Representative Lookner already stated that, but.
Yeah.
Okay, so are we good with the reports that we haven't received? And what we're gonna do about it? Yep, Senator Curry.
Thank you. Yeah, so your question on the unbridged islands, I think that's included in the section of the bills that we're sending the Stern letter that says, hey, where is this?
Yeah.
And we need this. What's your plan? And so I think that's fine.
Yeah, my question, do we need something?
Representative Hassenfuss?
Yeah, do we need something more urgent because it's like we need to report out we need to report out a bill?
I don't think we're gonna be reporting out a bill on this. I'm sorry.
Okay.
Sure.
Okay. Representative Bunker?
That's fine. Page 2, Will, second one down, the Public Safety, Health and Wellness Grant Pilot Program. I
Yeah.
was familiar with that and my department was a recipient of one of those grant programs for the screening for cancer and mental health wellness issues. And I know a couple, by this, I can see a couple of other committees that trips into their neighborhoods too. I'd just be generally interested, are any of those committees, if not us, coming out with a bill that would perhaps implement that
Yeah.
ongoing?
And I will talk with the analysts for each of those committees as well. In fact, I've already had some conversations for HCIFS because they are one of the committees that are authorized to report out legislation and receive the report. I just had the conversation yesterday, I think it was, that they haven't received it either. But it's a good point because also on the Unbridged Islands bill, we also gave Transportation Authority. So I don't know if they had some other separate bill or some other resolve that somehow, fix these issues or where it came from, but there will definitely be some communications with those committees about, are you doing something that's parallel to this or accomplishing something similar? So yeah, that communication will take place.
I'll be all ears to hear that because I know the pilot program is very worthwhile and a lot of good findings and output. I'm hoping somebody will see that go to fruition and make it a regular program or not. So thank you for checking.
Yeah.
So are we all set with what we're gonna do with the reports? Are there any other thoughts on reports we haven't received? And what we're gonna do about it? We're good.
Okay.
Okay, thank you.
Yep. Which one is that?
So Representative Hassenfuss?
Yes, I'm just next week's schedule. We don't have session days, is my understanding. Will, has AFA set their schedule yet?
Not a formal one, no.
Okay, so we have, I believe it's maybe 2 more public hearings of non-committee bills.
Of bills that have been referred to us, I think that we could get maybe 1 or 2 more that have not been printed yet. But yeah, as of right now, just 2.
Yeah, so there's maybe 1 morning of public hearings left, and then we have, the work sessions that we haven't got through. But my thought is next week, with there being no session days, if we are asked to come in for AFA, that would probably be 1 day of next week. We'll try to make sure that any work we do is all contained within that 1 day of being here for AFA. Does that make sense for everybody?
For next week.
Yeah.
That will save you 1 day's travel.
Yep, 1 day. Beg your pardon?
So do we know which day next week that'll be?
I don't think so.
No, there's nothing published. Yeah.
We may. Do you know, are all the committees going to meet next week? Or is
No.
Yeah, so I don't even know if we will be in front of AFA next week, but
Alerted to what the schedule is going to be? I mean, very soon,
For
very soon.
supplemental budget?
for next week.
For the supplemental budget
supplemental
hearings,
budget,
yeah, I think it should be very soon.
Okay.
I think we should know it today or tomorrow.
Representative Milliken?
Yes. I just we're not on the draft schedule. So I know that.
Okay.
Yeah, so
Representative Hassenfuss?
we're gonna just next week, it'll be fluctuating, but know that it won't be more than what AFA asks us to come in for.
Representative Nutting?
And traditionally is a skeleton crew from the policy committee that shows up for that. And I wouldn't be driving a long distance to come to that, but that's just me. I probably will be here.
Zoom is also an option.
Yes.
I'll break my promise, that's one last thing. As it relates to those joint committee meetings with AFA.
Yep.
Do I recall correctly that each committee is asked to prioritize the top X number of bills that have a fiscal note?
At the end of session.
For which that's the end of the session,
Yeah.
not during these joint hearings per se.
No,
Okay.
no. There, any other thoughts? Representative Milliken?
Thank you, Madam Chair. I'd like to make a motion to adjourn.
Any further discussion? All those in favor?
Everybody have a cookie.
Cake.
I'm taking a big slice of cake.
So hard to break the chair. No, stop. Sorry.